Lordship,
Shani, please come tomorrow. There's an indication in the list.
next date
Your Lordship,
is on
Your
20.
Lordship,
I had my next date before the lower court is on
Maybe,
22nd.
please come tomorrow. There's an indication in the list.
Your
Mentioning,
Lordship, under complaint.
Lordship, my matter will take just 5 minutes. My occupational charges was rejected and cost.
Madam, please come tomorrow. Tomorrow is 26th, 27th is the day after. Yes, call the list.
My lord, may I be permitted? There is an urgent.
Please come tomorrow.
My lord, kindly seize the order. My lord, kindly.
না আমার এখানে আজকে
My lord,
Yes. Slip the name.
this matter was fixed on Saturday by Justice Chaudhuri for interaction with the minor child. The minor child resides in Bangalore, my lord.
Can you not wait till tomorrow to mention?
Well, if my lord wants to see the minor child, then I have to inform the same. There is a question of purchasing flight.
Please mention tomorrow. The matter is not in the list.
লর্ডশিপ আজকে আমার লিস্টে রয়েছে আপনি অর্ডার দিয়েছিলেন 25 তারিখ হিয়ারিং শুনবেন
ঠিক আছে।
কিন্তু আজকে আসেনি
কালকে মেনশন করবেন। Yes. Call the list.
Item number one, the Lordship, I am for the opposite party.
My lord, in item number 1, appearing on the behalf of the petition, if my lord can recollect, my lord, this is that matter where, my lord, we have filed order 39 rule 1 and 2 application along with an appointment of a receiver before the court that has been
You are
not
appealing for
recorded.
the opposite party.
Item number one, your Lordship.
Yes. So what is your instruction? Applications are filed.
Lord,
Order 39, rule 1 and 2 and order 40.
my lord, my instruction says yes, the applications have been filed, but only one thing, your Lordship. If your Lordship kindly comes to page number 32 for once. Page number 32 of the.
Yes, page number 32, yes.
My lord, they have prayed for appointment of a receiver.
No, no, no. That
That is
is
the only thing.
Ashun. Yes,
The section 24 application. Now, my
for
lord,
transfer.
for transfer. My lord, the husband had earlier filed a suit for restitution of conjugal rights. That was filed in Barakpur. Annexure page 16. This honorable court had transferred the suit from Barakpur to Ranaghat. Now, my lord, now the husband has come up with a divorce application. My lord, before the landed court at Barakpur, the wife is a resident of Ranaghat. Could it be transferred to Ranaghat?
Have you served?
But I have saw Mr. Bani Israel is appearing for the opposite party. My lord, yesterday I had spoken to him. He says that his client is not contacting with him.
Then I am extending.
My lord,
I'm-
kindly, my lord, only thing about this lady is not getting maintenance. If the
But this is appearing under the heading
extension of
interim
interim
order.
order.
So I cannot take it up finally.
Lordship.
When the interim order expired?
But the interim order has already expired.
When?
What it has? My lord, it
You
was
file the application within time.
no, but
No.
there is no application. Because my lord, we want
So you have
dispo-
not filed any
No.
application.
But this is my lord, for my lord, we are praying for disposal of this matter.
Uh,
The interim order, my lord, was lastly extended up to 30th September 2024.
uh, the learned advocate appearing for the petitioner submits that
My lord, in this matter, this is a CO application. This is a Sarfaesi matter.
yes, yes.
The
Yesterday, my lord,
essay is pending on the self same ground.
Who are
Another,
you? You are for the
I am
bank.
for the bank.
Yes.
In the self same cause, other. Wait, I think, Another CO was filed earlier, which
That I have
was disposed
stated,
of
that I have
on.
sta- that I have stated.
Oh.
But my most funny thing is that, my lord, the order is unsigned.
Mr. Pal, he has been engaged by his client. Allow him to submit.
My lord, on the last occasion, when Justice Raja Baschoduri was pleased to pass this order, inter alia granting them to 2 weeks stay from 6th of February 2025, and thereby they had the opportunity to ventilate their grievance before the DRT.
They have not done so.
They have not done so.
They have not filed any application before the DRT.
No IA application has been filed before the DRT, and the next date is 27th of February. And in the meantime, after expiry of that stay, the bank has taken possession.
Till which date the stay was there?
Up to 20th of February, and yesterday
20th of February. So whether any order was passed by the
there is no stay order from DRT either.
No. I appreciate that.
Hmm.
There is no stay order. By which order you are permitted to take possession? Show me that.
There is DM's order that I can
Show me that. DM's order.
না পিছন দিক থেকে পাবে। আমাকে দিন।
এটা এক্সটেনশন করলাম।
ACGM's order, that is
তোমার ইয়ে হবে না।
that is the right.
Yes. By which order you are allowed to take possession?
এটা দিয়ে দিন। আমাদের কপি নেই। সার্ভিস করছো? No,
There was no subsequent order.
no subsequent order.
What is the order at page? Last page of this civil revision application.
Civil revision has not yet been submitted to us. No copy served as yet. This civil revision
All
application.
right, Mr. Pal, give him a copy. Last page.
Yes.
Was any order passed on 18th of February 2025? Yes or no?
We will have to take instruction, my lord.
What instructions? You paid for extension of the order on 18th, and on your own statement up to 20th, the interim order was there. How could you file an application for extension when the interim order was in subsistence? Take instructions, come at 2 p.m. Take instructions, come at 2 p.m. I need 2 p.m. Also bring the copy of the application where you paid for this extension of the interim order. 2 p.m. record. Yes, next.
Or Lord, in this revision has been filed for expeditious disposal of the eviction suit filed in 2022. My lord, till date, issue has been framed, my lord. It is pending before 5th Civil Judge, Senior Division, Alipur.
Issues have been framed.
Yes, my lord.
You are for the plaintiff.
Yes, my lord.
How many witnesses you will examine? That you don't know. this application under Article 227 of the Constitution.
Yes, here.
Next matter.
Yes, man.
Yes.
Expeditious disposal of the withdrawal petition, my lord.
You want to withdraw the suit?
Yes, my lord.
The learned advocate appearing for the petitioner submits that Mr. Das, this is a matter of 2023. I do not have determination. You are not checking the determination.
I am extremely sorry. My clerk should have checked it.
Item number 2
But the
that
only thing is, my lord, section 24, your lordship says determination. Because, my lord Justice Bivas Ranjan De does not have the determination for section 24. Section 24 is exclusively your lordship's determination, even if the matter be of the year 2023.
section 24 একটু ইয়ার বলে দেওয়া নেই। All right, let me inquire thereafter.
Lordship. But section
Ask
24.
your junior to take information after
I shall.
2 PM. একটা খোঁজ নিয়ে নেবেন একটু 24 টাতে যদি তাই হয় ঠিক আছে। Yes, থাকুক আপাতত তারপর। Yes, call the next matter. 6, yes.
Kindly see the order, lordship, last order, lordship, and you see ex parte vacating application filed by the opposite party, lordship. This is allowed without contest, lordship. Lordship, last order and lordship order.
Ex parte, it was fixed, it was vacated.
Lordship, first
You
day
want
was-
an ex parte degree?
One minute.
Do you want an ex
First
parte degree or you want a contested degree?
First day file. Receive, I made an objection, but not allowed. Lordship,
I will record your objection here and I will.
Lordship, kindly consider. Lordship, kindly consider. Lordship, kindly see, lordship, page 27, 28, lordship.
Why do you want a ex parte hearing? You do not have a very good case.
Lordship, he is not releasing any that. Lordship,
Ex parte hearing has been.
one, Lordship, kindly page 28, Lordship, kindly see the page 28, Lordship. Defendant number 5, no take steps, hence the instant suit proceed against him. Lordship, ex parte vacating, file application for ex parte vacating, file 1 day.
You were not given any opportunity to oppose that.
Lordship,
That is
kindly
your.
consider, Lordship, kindly consider, Lordship. Lordship, I am not to oppose this application, Lordship.
I will record your vehement objection here.
1 minute, Lordship. Lordship, ex parte vacating application file 1, 2, and 3, Lordship. Other is not filed. Lordship, 28, page number 28, Lordship, last says that ex parte against S1 5, Lordship.
This
But-
shows you do not have any case on merits. This
Lordship,
shows you do not have any case on
and-
merits.
Lordship, kindly consider. You kindly consider. Copy served, Lordship, then Lordship. Copy served, other side, thereafter, Lordship.
What copy, sir?
Lordship, Lordship, kindly consider, Lordship, ex parte against the respondent 5. Respondent 5 not file any application, Lordship, for vacating application. File application for vacating only 1 and 3.
What is the suit for?
To put declaration of injunction, Lordship. So kindly consider.
You are the plaintiff.
Lordship. Page 28, Lordship. Ex parte.
This shows you do not have a very good case on merit. You want a ex parte degree.
Kindly consider only for 1, 2, 3. File a vacating application.
All right.
But court is directed to file.
All right, I am directing you to serve. Suit has to be stayed.
Item 7 and 8, Mr. Bhattacharya is actually.
Since I am not inclined to take up this matter on personal ground, this matter stands released from the list of this bench.
The petitioner lordship,
Yes, yes.
she has come to the court lordship, but she has to leave the court because her close relative was expired lordship today. So I am praying 1 week of time lordship.
An accommodation has been prayed for by the learned advocate for the petitioner on
Petitioner, my lord. My lord, I'm for the opposite party plaintiff in the suit, my lord. I am on caveat. The petitioner is the tenant, my lord, in an eviction suit, my lord. And the eviction suit was filed on the ground of reasonable requirement by the plaintiff. And petitioner, the tenant.
for the opposite party.
I'm for the opposite party. We were on caveat,
Caveat, my lord.
and therefore we have been
Yes,
served.
yes.
My lord, the tenant filed an application for local inspection order 39 rule 7. It's in page 58, my lord. And
Page 58.
58 is the application, my lord.
Yes.
And the order is, my lord, page number 62. And the application that was rejected on 10th January 2025.
And the ground was that the schedule was not related to the suit. The schedule of the local inspection stated in page number 60, my lord. Running page number 60, page internal page number 3 of the application. My lord, as per the
Where is your written statement?
my lord, it is page 50,
Page
55.
55.
No.
35, my lord.
Sorry, my lord, 35.
35.
Yes.
What have you stated about the alternative accommodation?
Me, my lord.
Yes, about his alternative
Yes, my
accommodation.
lord.
What have you stated in
Yes,
the
my
written
lord.
statement?
This, the property is in a building, a top floor, my lord. And this
Yes.
property, this building, and the plaintiff has 5 buildings within this complex, my lord. And 5 buildings, my lord.
Yes.
That is premises number 55 K
But
T.
you have not sought for the local inspection of the other buildings.
Yes, my lord.
Have you sought for the
my lord.
local inspection of the other buildings?
That is page number 60, the schedule, my lord.
What is the ground on which it was rejected?
That was rejected that the property for which the local inspection sought for, it was the non-suit property, my lord. Because I am the suit property is at the top floor of the building number 555, 33, sorry, my lord, 33P.
Yes, you are appearing for the opposite party.
My lord,
You have relinquished your claim of reasonable requirement.
Yes, my lord. There, the suit, I will indicate, my
I
lord.
will record that.
My lord, will record one
What is
thing.
the suit for?
My first ground is the suit is for default due to non-payment of rent, reasonable requirement, and also third party interest created by subletting.
Subletting.
These are the 3 grounds on the basis
You
of
are
which I
relinquishing your
Fine.
claim of
My lord,
reasonable
it has been
requirement.
recorded
End
in
of the
that
matter.
order. Yes, my lord. And my lord, secondly, my lord, reasonable requirement is also a matter with regard to where the burden of proof lies on the
No, if you
plaintiff.
say reasonable requirement, then local
No,
inspection has to be made.
I am
That there is a recording that you have relinquished your claim of reasonable requirement.
I have made that submission. My lord, that submission will stand. On that basis, my lord can dispose of this because it does not require interference at all. Only on those grounds.
What do you say to that? If
They are relinquishing their ground on additional.
Then you have nothing to say.
It will be adjudicated on the rest of the grounds.
Yes. My lord. By the order impugned, the application under Order 39, Rule 7 of the Code of Yes.
My lord, item number 11, I am for the petitioner, my lord.
Yes.
My lord, this is my transfer application. I'm seeking transfer of a suit instituted by the husband for dissolution of marriage from additional district judge Fourth Court Barashat to additional district judge Siliguri at the under district judge Siliguri.
What is the stage of the suit?
My lord, it is at the preliminary stage for filing written objection, my lord.
What is the next date fixed?
My next date, my lord, in the next month, I've been told, my lord. My lord, the primary ground is my lord, distance, my lord, and proceeding under section 125 is pending, my lord.
Proceeding under section
125, presently 144 of the BNSS.
Where it is pending?
Siliguri, my lord.
The learned advocate appearing for the petitioner submits that the
শুনবো কি করে?
where it is pending?
But additional chief judicial magistrate.
Additional
Siliguri,
chief
my lord.
judicial magistrate at Siliguri.
Siliguri, my lord.
Additional chief judicial magistrate at Siliguri.
And there's a 4-year minor child also with me.
So he further submits that the petitioner has to look after a minor. Yes, next.
Grateful, Lordship.
I'm appearing for the petitioner. This is a transfer application. Lordship
Transfer.
transfer
Yes.
from additional district judge first track Chinsura Hugli to Alipur district judge. The petitioner is suffering from depression and she is not dependent.
What is the stage of the suit?
Lordship status.
Stage of the suit.
SRAD. It's the second time it's appearing for a written objection. The next date is on 22nd of April.
So you have not entered appearance.
Lordship.
You have not entered appearance.
Entered appearance.
When did you enter appearance?
On the last occasion, Lordship. Lordship. 17th of February.
The last date is, the next date is on April.
22nd April.
22nd April. Any criminal proceedings pending?
No, Lordship.
No. Ashun. This application under section 24 of the Code of Civil Procedure. Yes.
Your Lordship, I'm led by Ms. Labanashi Sinha in this matter, Your Lordship. Your Lordship, she is engaged in some other court. I'm praying for a Passover at 2 p.m. or not today, Your Lordship.
Passover next.
Obliged, Your Lordship.
This is my application, my lord, arising out of an order whereby, my lord, Section 8 of the Arbitration and Conciliation Act had been allowed. The suit was, my lord, referred to arbitration. After application filed, after filing of written statement, after filing of, my lord, Order 7, Rule 11 application, and after 3 years from the institution of the suit. My lord, now they are appearing, my lord, they say that they have, my lord, filed an caveat.
Yeah, we are on caveat.
But, my lord,
You have not served a copy.
no, my lord, I have not received any caveat.
All
My
right,
client.
serve a copy.
I'll come back. My lord, I shall be, my lord, very fair. My lord,
The learned advocate on record of the petitioner is directed to serve a copy of this application upon the motion.
I'm so grateful.
Yes, listed motion.
I'm
Yes,
so grateful.
next. Call the next matter.
Defendant number 1 is the petitioner before your lordship, my lord, in a suit for recovery of possession, my lord, upon removal of encroachment of descheduled property.
What are you paying, Mr. Mukherjee? Expeditious hearing.
On 8th November 2005, my lord, the local investigation application allowed. 19 years lapse, my lord, till date no report is being filed. For 19 years, I took out an application that either direct the commissioner to file a report or to return the writ so that new commissioner may be appointed. That application was
Who is
also
the commissioner?
my lord, kindly takes up the order, my lord. It's page 63. 63, my lord. Your lordship will get, my lord, the details at page 65.
The learned advocate appearing for the petitioner submits that
Subject to the leave of the court.
Yes.
In fact, application made by the opposite party under the Provincial Insolvency Act. But this act has already been repealed in the according to the Insolvency and Bankruptcy Code 2016. But the court below has granted the relief upon the respondent. If your lordship kindly see the order under challenge.
Only service returns, only directions were there to serve. You approach, take that point. Raise all issues before.
Yes.
Before the learned additional district.
Already my salary has been held up It has been taken from my account and it has been held.
13th of February was the date fixed for appearance. Why did you not appear? What is
February, my lord?
Yes, for appearance and SR. Why you did not appear on that date?
Subject to the leave of the court on the very particular day. I have some personal problem.
What is the next date fixed?
My lord, then
What is the next date fixed?
March, date is fixed in the month of March.
Appear there and take all points.
My lord, subject to the leave of the court. The purely a question of law. If your lordship kindly see.
Sir, these proceedings cannot be set aside without hearing the other side.
Yes.
So then I have to direct you to serve. It is to be kept pending. Instead of that, you can approach that court, take all points there.
Let a direction be made upon the other side to appear. It is purely a question of law, a repealed act. If your lordship kindly see.
You take all points, it will be decided.
My lord, subject to the, if your lordship kindly allow let a direction be made, let them appear before your lordship. Only the question of substantial question of law, lordship, we make this application under Article 227, my lord. But set right the proceedings of the court.
The honored advocate appearing for the petitioner submits that the yes, who is appearing?
Yes, my lord, I am for the petitioner, my lord.
Yes.
My lord, there is no dispute, my lord. My defense under Section 7(3) of West Bengal Premises Tenancy Act has been stuck off. But my tenancy and relation between landlord and tenancy is not disputed, my lord. Only the period, my lord, since February 2012 to July 13, I have paid the rent, but no rent receipt has been issued. And during pendency of the 7(2)
But you
hearing,
did not
my
file
lord.
the 7(2) application within time. You
Yes, my lord.
You filed the 7(2) application with Section 5.
Yes, Section 5 not applicable, my lord.
So,
but my
rightly
relationship
rejected. Rightly rejected.
My lord, my relationship between landlord and
Maybe.
tenancy is not
Maybe.
disputed.
Maybe. Ashun.
My lord, my defense, my lord, on judgment, my junior will hand it over on judgment, my lord. Your lordship, please, if your lordship.
Yes.
Yes, my lord, in this, that eviction defense is stuck up merely on the ground that petitioner did not apply under Section 7(2).
But
Here
you have
my
applied here. In this case, you have applied with Section 5. Section 5 is not maintainable. Uh,
Section. My lord, when due to some period, my lord, from if your
Cannot
lordship
be held.
allowed to
Cannot
deposit,
be held.
if your lordship allowed,
You have not brought the Supreme Court judgments. Our larger bench judgment. You have not brought that. What can be done? This application under Article 227 of the Constitution. I appeared.
my lord, only indulgence, my lord. Any impugn order only
Yes,
application under section 7.2 has been rejected.
Yes,
not
yes.
the 7.1, my lord. That is
I follow
defective.
that. 7.2
Defective is
also,
order, my lord.
Section 5 is not maintainable.
My lord, section
I'm-
7.1 is
7.2, sir, it was rejected. Section 5 is not maintainable. This is 7.2. The learned advocate appearing for the petitioner places reliance upon a decision of a court.
Number 18, my lord. The matter was filed by Mr. Gautam Kumar Pincha in person. And my lord, subsequently yesterday.
Can I take up this matter?
Yes, that is why,
Okay,
my lord, I am
since I'm
just
not inclined to take up this matter on personal ground, you need not so. Since I'm not inclined to take up this matter on personal ground, this matter stands released from the list of this bench. Let the paper. Call the next matter.
My lord, I beg to have the petitioner, my lord.
Yes, Mr. Ghosh.
Application has been directed, revision application has been directed against the order allowing the application under section 5 of the Limitation Act in filing of the miscellaneous case number 913, order 9 rule 13.
Section 5 allowed, Mr. Ghosh.
I'm telling why I have come. Section 5 could have made a liberal approach. I myself, but why? Opposite party made an absolutely false and incorrect statement before the landed court below. Why? Opposite party appeared before the landed court below, contested the matter, took several times for filing of the 770 applications, did not file, did not
Mr.
file.
Ghosh, I can
statement.
expedite the order 9 rule 13. Otherwise, it will be kept pending here.
No, well, kindly.
Otherwise, it will be kept pending here because they have to be given an opportunity. I can expedite the order
I
9
can serve notice upon the other side.
Yes.
So that the, well, kindly
But
see
this-
the entire
this
order
tot-
sheet.
The
Entire
suit is to be stayed.
suit has been decreased.
This case is to be stayed.
This case I am fixed on 1st March.
So I can expedite the this case. I think that will be better instead of this matter-
Without making any influence.
without granting any unnecessary
No,
action.
being influenced with the order of section 5. Because
Section 5 is a different thing altogether.
No,
That is consideration of delay.
Oh, well, okay.
All right, I will make that observation. Ashun. This
Appearing on behalf of the petitioner, your lordship. Lordship, this suit for partition filed by my predecessors in the year 1988.
What is the stage of the suit, madam?
stage, your lordship, the hearing of application kindly sees the order.
Under order 39 rule
Under-
7,
Yes, your lordship.
it has been fixed on order 39 rule 1 and 2 is also pending.
Yes, your lordship.
This application is at the instance of the maybe you have to come before this court or the other side. Yes,
Sure.
let those applications be disposed of. Yes,
Lordship. Grateful.
next.
Madam, I'm the plaintiff petitioner in a suit for eviction of trespasser. Original suit filed in 2016.
Expeditious hearing.
Yes.
Mr. Banerjee, you are appearing in an expeditious hearing matter.
But
I
I'm
will
in,
reject this application. I will reject this application.
but I'm in such a situation since 2016 the client could not get any relief. Again,
Expeditious hearing, if you move, it will be rejected with
let
cause.
my learned junior move.
Yes, thank you.
My lord, this matter has a checkered history, my lord. Initially, a eviction suit was filed. Thereafter, the main tenants died.
What is the suit for, madam?
It's a suit for eviction.
Eviction under which act?
Now it has been changed. Initially, it was filed under the West Bengal Premises Tenancy Act. After the death of the original tenant, 2G came. Now it is under the WPT Act, eviction of a trespasser, my lord.
Yes. What is any application pending?
Yes, my lord. 150, an application under section 151 is pending, where I have.
What is the 151 application for?
It is for imposing occupational charges in respect of the suit
During
property.
the pendency of the suit.
Yes, my lord.
Taking help of the Supreme Court judgment.
My lord, that is pending, my lord, and they are not there on the date when the matter is fixed. They are taking adjournments, my lord. That is,
What is the stage of the suit?
my lord, stage of the suit, my lord. Initially, everybody appeared. Thereafter, we had to serve it again when the suit.
Accepting the written statement at that stage.
No. There are total
That is
6
the order of
defendants.
29th of November for filing Vakalatnama, accepting the
Only
written
one
statement.
defendant, ma'am.
Written statement has been filed by the defendant number
Yes,
3.
my lord. Yes, my lord. They have
Ashok.
filed. It is running. There are only
This
2
application
defendants
under
left in the
Article
suit.
227 of the Constitution of India is at the You have to come.
22.
Yes.
My lord, I am appearing for the petitioner defendant in this.
Yes. What do you want?
My lord, I am agree for three reasons. Three issues are there.
What is the impugned order?
Impugned order is at page, my lord, after page 222,
Yes.
228.
Yes.
My lord, this order has been passed by the learned trial judge without any specific provisions of law. Like, my lord,
What is the order? What was the prayer?
prayer is for giving a direction to the SP, Bakura, to look into the matter whether the injunction order passed by the learned trial court is taken care of or not, whether it is
Cannot be
followed.
done. There is no provision in the Civil Procedure Code.
Yes, it is there. Order 39 rule 2A is there.
Violation.
For
So
violation.
151 is not maintainable.
Yes,
Where is the AIR 85 Calcutta? You have not brought that. You will not bring that. Anything more?
Yes, my lord.
Yes.
My lord, I have a judgment, Supreme Court judgment also.
It says it cannot be done.
Yes.
Give me the Supreme Court judgment. And what is the other application for?
Yes, my lord.
What was the other impugned order?
Other impugned orders, my lord, the learned trial judge is passing orders on put-up applications without giving any notice to us.
Order 39 Rule 7 allowed.
Three number of yes, allowed twice.
Show me the points.
Yes, twice. Three numbers.
Show me the points. Which page?
Yes, my lord.
Motions, you have to move fast, sir.
Yes, yes, yes.
Yes. Which page?
My lord, the next page. After this 2412 order dated 4/1/2025.
What is the suit for?
Is a suit for declaring my two title deeds void, to revoke the two title deeds of the suit for nullity of the title deeds, my lord.
Yes. Where is the Supreme Court judgment?
Yes, my
lord. Want to show?
My lord, kindly come to paragraph number 28. Paragraph number 25 onwards is
According to you, Order 39 Rule 2A is an alternative remedy, so 151 is not maintainable.
yes, at least
That is
one,
your submission.
that is submission. At least 150.
This is well settled. This is a well settled proposition. 151 cannot be invoked if there is a specific provision in the code.
Yes.
That is why I wanted to know whether you have bought AIR 85 Calcutta.
No. My lord, one more thing. At least
This is a well settled proposition.
Yes,
151 is not maintainable if there is a specific provision in the code. But even Order 39 Rule 2A is there. Section 151 is maintainable.
My
It
lord,
has been held.
at least 151 should have been written. It is also not written. Just a plain application code is.
Caption is not material. Where are those line of judgments? We will not bring that.
Yeah.
Is caption material or the substance the court has to look into?
Yes. My lord, one more thing. It is. My lord, the court is not passing orders on put-up applications without any notice to us. So, and the dates are changing again and again. My lord, there are 4 number of put-up applications filed.
By the order impugned. Yes. None appears for the petitioner at the time of call. No accommodation has been sought for either this.
Yes, I am for the petitioner, my lord.
Judgment to ফেরত দিয়ে দেবেন আগের matter. Yes.
Yes, my lord, petitioner filed a title should be before the learned civil judge junior division
Yes.
for declaration and peaceful possession.
Yes.
Herein also filed a petition for local investigation
Yes.
for proper adjudication.
Is this matter where I asked you to
Yes,
bring
yes,
the written
yesterday
statement
I
from
could not
the
comply.
written
Yes, yes,
statement?
my lord. This is the plain before the learned court.
Where is your written statement?
Written statement.
Yes, written statement. This is not the plain. This is an application under Order 39 Rule 1 and 2. Where is your written statement? You want to prove your case in the written statement by way of local investigation. Where is the written statement? You have
My
not
lord,
got.
my lord, please. Otherwise, the petitioner will be in deep trouble.
What? You have,
Actually,
you have not brought the written statement, sir.
My lord, I
I
do
will
not.
give you time to bring the written
Yes,
statement.
my lord, I do not claim the entire property. I claim only on 3/4 the property, and then the according
The
to
26 Rule 9 cannot be allowed at the mere asking.
yes,
You
my
have to
lord. Yes.
satisfy.
Only local
Cannot be
investigation is
also for
required.
the purpose of fishing out evidence. So you have to show what case you have made and for that whether it is necessary or not.
My lord, please adjourn the.
Though the matter was adjourned yesterday, that is on 4th of February 2025, to enable the petitioner to bring the copy of the plaint.
Lordship, on behalf of Mr. Anjan Datta, I am praying for not today.
Where is he?
He is could not come.
You are the advocate on record.
No, no, no.
You are not the advocate on record.
Yes.
Then it will go to the month list of June. You want that? You want that? I've seen the impugned order.
Only not.
I know the reasons why you are not coming. Ashun, an accommodation has been paid for by the learned advocate for the petitioner.
My lord, primarily, my lord, I just missed out the brief today, my lord. Actually, I was ill for last 2 or 3 days, my lord. That's why I could not come yesterday. Will it be, my lord? It's my humble prayer that, my lord, we kindly take it up this matter tomorrow. I am the
Nothing is
advocate.
there. Section 5 rejected in 7172.
No, my lord, I am the advocate on record. I am praying for an unconditional apology. Just only I missed the brief today. Will it be taken up, my lord, tomorrow? Only one.
You can take my brief.
My lord,
Only the brief is the problem. Yes,
it
pass over.
It
will
takes,
not
my
take
lord, some time, my lord.
It will not take more than
My lord,
5 minutes.
kindly, my lord.
Go to the impugned order. Yes,
Kindly, my lord, kindly, I am
yes,
praying
yes.
for.
Call the next matter. Call the next matter.
Kindly, my lord.
Take the brief. Problem is you did not have the brief. Now take the brief. Go to the brief. Yes.
Lord, it
Yes,
needs
madam.
some time to, my lord, prepare, my lord. Kindly, it needs some time to prepare, my lord. Kindly take it up on tomorrow, my lord.
2 p.m. 2 p.m.
My lord, kindly, this is my humble prayer, my lord.
আসুন রেকর্ড করে নিন, an accommodation has been paid for. দিন ফাইলটা দিন। It will appear in due course. Yes,
My lord,
take your time to prepare. Yes,
my lord, this matter was taken up yesterday, and according to the order sheet, it was supposed to be in the monthly list of April.
this was supposed to appear in the monthly list of April.
Yes, according to the order yesterday, my lord, this was recorded as well.
Yesterday order was passed.
No, not order. It was
My lord, we are appearing on behalf of the petitioner. My lord, this matter was appearing yesterday. My lord was pleased to pass an order also. My lord, this is the order copy.
No, this is 634. This is 635. What are you saying? This order is of 630. Oh, এখানে তো 630.
My lord,
ও 634 টা তো অর্ডার পাস হয়ে গেছে। ফাইলটা তো নেই, তো ম্যাটারটা লিস্টে দিয়েছেন কেন? আসুন। The file which has been handed over is 635. আসুন, the
Lord, take it up at 2 p.m. I prepared myself, my lord. I prepared myself, my lord.
I gave you that opportunity.
Yes, my lord.
You did not avail that.
Yes, my lord.
That is why I had to pass that order.
Yes,
I had
my
to
lord.
dictate 4 lines of the order.
Needs to be, my lord, next problem.
I gave you that chance. I
Yes,
gave
my
you
lord.
my brief. I told you.
Yes, my
My
lord.
lord, 2 p.m.
2 p.m., my lord.
ওই অর্ডারটা কেটে দেবেন 2 p.m.
Unconditional apology, my lord. Huh, 26.
I was there few days back.
Yes,
I know something. Yes. Yes.
My lord, I am appearing for the petitioner, my lord. This is an application, my lord, for an expeditious disposal, my lord. I am the defendant in the trial court, my lord, in the court.
Expeditious
I have
disposal of what?
Order 39 Rule 4, my lord. I have made an application, my lord, of under
Order 39 Rule 4.
Yes, my lord. For
You have
vacating
filed your objection to Order 39 Rule 1 and 2. You have filed your application objection to Order 39 Rule 1 and 2.
No, my lord, no, my
You
lord.
don't wish to file your objection.
Yes, my lord.
So
Only the, my lord, let me place my case. My
you
lord.
file your objection.
My lord,
Order 39 Rule 1 and 2 and Order 39 Rule 4 has to be will be hard together.
We will file, my lord. I just want
How
to,
soon you will file?
my lord, that, my lord, I will take instruction, my lord. That, my lord, kindly, my lord, one thing, my lord, I want to place, my lord. My lord, kindly seize the, my lord. I will just hand over the plaint, my
I
lord.
cannot decide the matter on merits. Ashun. This application under Article 227 of the Constitution of India is at the
নেবেন
29 yes.
29, Your Lordship, appear for the petition. Lordship, the order dated is 4th of December 2024.
What is the nature of the order?
Lordship, it's my order 10 rule 2 application which has been rejected. Lordship, the
Order 39 rule 2.
Lordship, order 1 rule 10 2.
Order 1 rule 10
10
2
2
was rejected.
Was rejected.
Filed by you.
Filed by me.
What is the nature of the suit?
Lordship, the nature of the suit was that, Your Lordship, there are two dag. That is one where the plaintiff
What is the nature of the suit?
Lordship, I'm coming to that. Lordship, it is with regard to, if I can say in one line, that the petitioner is trying to establish his claim over my plot of land. Lordship, that plot of land does not belong to the plaintiff. Lordship, now very tactfully, he has referred to 3 premises, wherein the number, which is at page 160, RS plot number, he has referred to LR, whereas the plot numbers are to be ascertained with regard to the RS plot number. The plaintiff is only
It is at page 34.
Lordship.
Give me a minute. Take your seat.
Lordship, kindly takes page 160 along with it.
I will come to that.
Lordship.
Where is your application under order 1 rule 10?
Page 107. Very small application. Page 2 onwards.
107.
107. There's a prayer and thereafter page 2 onwards. Paragraph 2 onwards. 2 and 3. I have elaborately explained in my written objection. Objection. 870.
No, you are the defendant number 1.
Lordship, I'm the defendant number 1.
So I asked you whether you wanted to be impleaded. No.
No, I don't want to be impleaded. This is with regard to 4205 and the dispute is with regard to 4204. So I need not be added as a party at all. Now what the plaintiff has tactfully done by adding me as a party and keeping the defendant number 2, which the plaintiff is also saying that he is missing for 100 years. He is trying to establish his claim over a plot of defendant number 2 by roping in the defendant number 1. My plot I have already sold. And to whom I have been sold, they were never made a party.
What is the ground on which it was rejected?
Lordship. Lordship, may kindly see this is just a 1-page order. December 2024.
When did you sell this property?
Lordship, in the month of September 2022.
Prior to the filing or after the filing?
He has filed in the month of November 2020.
Prior or after?
Prior.
Prior to the filing of the suit?
Filing. November file করেছো তো এটা? সুটটা নভেম্বরের। আরে উনি ওখানে দাঁড়িয়ে এদিকে আসুন না। এখানটা দাঁড়াও, এখানটা এটা সুটটা নভেম্বরে ফাইল করেছিল। এই জিজ্ঞেস করো তো। September 2022. It was an application of 28th November. No, 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 no. No. Lordship, I stand to correct here, Your Lordship. They have filed the suit in June, and the sale proceeding by then was continuing.
The plaintiff
was-
is claiming right by way of adverse possession.
Adverse possession.
So then you are a necessary party because at one point of time, you were the owner. Maybe subsequently you have sold.
Lordship,
You may
that is
choose
not
not
my
to
issue.
appear.
Lordship, that is
You may
not my
choose not to appear. It will proceed ex parte against you.
Lordship, that is not the issue. If I can explain only in one line.
Because he wants you, because he claims adverse possession,
Lordship.
he sought to deny your title. If he succeeds in proving, then your sale, the subsequent purchaser will also not get a title. If he succeeds in establishing his title, he says you did not have any right to sell because he has
That is not
acquired
his
title.
case.
That
That is
will be
not his
decided
case.
in the
He-
suit.
Lordship,
You need
he-
not participate in the suit. You choose not to appear.
Lordship, may I explain? May I explain only one, Your Lordship? Lordship, what is happening, Your Lordship? He has the suit property. The petitioner is referring as Schedule B.
All right, you sir, Ashun.
Lordship.
By the order impugned, the I'm coming within 5 minutes. Yes.
Lordship, I appear for the petitioner, my lord, petitioner tenant.
Parte.
I appear for the petition. My lord, here the opposite party plaintiff, my lord, had filed an ejectment suit on the ground of reasonable requirement. The petitioner is a tenant, my lord, in respect of a shop room comprising of an area of 172 square feet.
What is the impugned order?
Impugned order is the order directing inspection by the Advocate Commissioner. My lord, I am aggrieved by the order because that inspection has been sought to be made, my lord, on the basis of the points given by the application of the plaintiff, my lord. In the written objection, as well as in my written statement, my lord, I have contended that there had been a complete suppression of material facts, my lord, because he is already in possession of the entire building. It's a G+3 vacant building, my lord.
Yes. So to ascertain that the local
No.
commissioner has been appointed.
The commission has been appointed only in respect of the area in the ground floor. We are just praying for bringing the entire building within the ambit of inspection of the ground floor.
The application filed by the plaintiff.
Filed by the plaintiff.
So did you file any application?
For written objection, I had
an objection that cannot be allowed on that. If you file an application, it will be considered. On your written objection, that cannot be allowed.
Lordship, at least this would mean, ma'am, this would lead to fishing of evidence,
No,
my
no.
lord.
This application is at the instance of the defendant.
Who is the petitioner applicable lordship unit?
Yes.
And I'm appearing for the opposite party number 1. The suit is for declaration, accounts, and permanent injunction. This order is directed, my lord, against allowing an application under Order 39, Rule 7, treating the said application under Order 11, Order 26, Rule 11, and also, my lord, disposing an application filed under Order 11, Rule 14, filed by the defendant 1 and 2, disposing, but in fact, my lord, the said application has been dismissed. May I place the order and your lordship kindly peruse the plaint.
Mr. Vadajaji, give me a minute. You are the defendant.
Yeah, defendant number 1 and 2.
Yes.
Did you?
Yes.
But your lordship kindly have considered that, my lord. Your lordship kindly peruse the plaint first.
Yes.
Page, my lord, 33. Prayer, Roman prayer 2, my lord. And he wants to prove his case, my lord. This is practically a fishing out of evidence. And, my lord, the one of the relief has been granted a degree declaring that the plaintiff is entitled to get the entire accounts of the profit and loss of the business from the defendant number 1 and 2. And defendant number 1 and 2 are liable to submit the account of the business as per report of the accounts commissioner. And, my lord, the accounts commissioner has been appointed, my lord, giving full access. Well, this is a suit for declaration that the partnership, this is a proprietorship business. Admittedly, this is a partnership business. Well, he has not called for, asked for, my lord, declaration that the deed of partnership is void and ineffective. And by this application, my lord, he wants to bring evidence before the court, before the suit is taken up for hearing. And, my lord, he wants to proceed in the matter. No prima facie case, but your lordship kindly peruse impugned order. There is the finding on paragraph 1, 2, 3, 4, 5th paragraph. Neither party filed any document in support of their claim. Now, our specific case that in order 11 rule 14 that he has filed the deed of partnership.
You have filed the deed of partnership?
They have filed deed of partnership. And your lordship kindly peruse my application under order 11 rule 14. Well, your lordship kindly peruse.
Where is that?
Yes, ma'am. Just a minute. Page 41, subject to correction, my lord. Page 42, your lordship kindly peruse paragraph 2, that the plaintiff filed the photocopy of the partnership deed along with the plaint. The suit will proceed. The situation will come. If the degree is passed, then, my lord, investigation commissioner can be appointed. And at the initial stage, this is a prejudging the issue, my lord.
May I just answer, my lord? My lord, my plaint case, if my lord takes up my plaint.
Mr. Chatterjee, that decree you have paid for.
Yes.
So can that order be passed at the interlocutory stage?
Yes, my lord. Under order 26 rule 11, my lord kindly takes up the plaint before taking up order 26 rule 11, because it's on the basis of the plaint that I will invoke order 26 rule 11. Now, my lord, in
then
the
what degree will get, Mr. Chatterjee,
yes,
on this?
Now,
for accounts, what degree will be
yes,
passed if the commissioner is appointed?
Yes.
He
yes, exactly.
verifies the accounts.
Exactly my point. Exactly my point. Now, my lord, in the plaint, my lord, the case made out by my client is, my lord, the plaintiff is the entire investor, my lord, for the running of this clinical establishment. And, my lord, these defendants, my lord, were employees, my lord, who entered into a pseudo partnership document for obtaining licenses. But my lord, in the my lord deed, if it is read in its entire context, my lord, they were having my lord salaries, my lord, in respect of their professional expertise, my lord, which would be shared according to their my lord the terms. Now, my lord, while virtue of continuing this, my lord, despite my investment, my lord, when I seek the my lord accounts, my lord, from them, my lord, they refuse to give me accounts, my lord, and they, my lord, invariably when they produce a part of the accounts, they say, my lord, my investment, which was around 33 lakhs and odd, they, my lord, show it as, my lord, 20 lakhs. And, my lord, where they have not invested any sum, my lord, they say that they say that they have invested 18 lakhs. So, my lord, my prayer comes in, my lord, this is a, my lord, sole proprietorship business to be declared.
Where is that allegation in the plaint?
Yes. My lord, kindly takes up paragraph, page 20, paragraph 10, my lord. I
Page
read
20, paragraph 10. Yes.
My lord, may I read just that getting such proposal from the defendant number one, the plaintiff asks the defendant number one to be partners of the said business should run as partnership business. And to start the partnership, all the partners will have to invest equal shares capital at the rate of 25%, each part from the liquid amount investment by the plaintiff in the said business establishment. That the defendants at that point of time opposed the proposal of their investment. They categorically stated they would join in the business in lieu of the remuneration against their services. They would not invest, but they would render their respective services to the establishment, and in lieu of their service, they would take remuneration, and they requested the plaintiff to run the business as proprietorship business. But papers ought to be prepared showing partnership business to obtain license from different establishment of government, semi-government, and local governments. But thereafter, my lord, paragraphs are relating to, my lord, investment made by me, my lord, paragraph 14, my lord, then, my lord, it continues with the investment continues up to 33 lakhs in paragraph 14. It is being shown. Then, my lord, paragraph 17.
Where is the partnership deed which you have filed along with the plaint?
My lord, it is his revisional application. I can
I
bring
have
that
filed.
document. My lord, I can bring that document.
Yes.
But
Because you have filed that prima facie shows that it's a partnership
my lord,
business.
even in
If that is
even-
so, you have to prove your case.
my lord,
If
even
you prove your case,
now,
that
my lord, it's a issue, my lord, where accounts has been sought for. My lord, my case is suppose, my lord, if I fail to prove it's sole proprietor, it's a partnership. But today, my lord, one of the prayer is, my lord, accounts where, my lord, it is shown that, my lord, my investment is 33
the
lakhs.
decree for accounts you will be getting.
So therefore, my lord, 2611 comes in. My lord, court will
At
appoint.
what stage?
My lord, kindly takes up, my lord, 2611. My lord, in a suit in which, my lord has got 2611. In a suit in which an examination or adjustment of account is necessary, the court may issue a commission to such person as it think fit, directing him to make such examination or adjustment. My lord, this relates no stage. But in a partition suit, my lord, stage is given. After preliminary decree, this would come in. So, my lord, this is not a partition suit, my lord. So, my lord, it's as a stage, my lord, where I have to invoke 2611, my lord, for assistance of the court. My lord, court can exercise this power. My lord, the commissioner who will do it, my lord, he will put to be a witness box. So, my lord, it's not a stage, my lord, this is the mandatory requirement of the court. So, it can come up even at this stage.
Prior to that, it is to be first prima facie found whether it's a proprietorship business or a partnership
My lord,
business.
even if it's a proprietorship business or a partnership.
Show me your documents which you have filed.
My lord, then it will be prejudging. My lord, the issue whether it's.
Show me. No, that is your case. You have relied upon that document.
My lord,
Mr. Chatterjee, you have relied upon that
the
document.
impugn order goes.
But
if my lord takes up the impugn order once.
yes. Do you have a copy of that partnership deed? Because the impugned order proceeds on the basis neither parties have
No, my lord,
filed these
no,
documents.
that impugn order proceeds even if it's taken to be a partnership or a sole proprietorship.
Yes.
This examination is required. My lord, this is the basis of the impugn order.
Yes.
My
But
lord,
if you have filed that document, if prima facie shows it's a partnership business, then the
Well,
question
even-
of
well, kind-
partnership and accounts comes.
kindly
There, Mr. Chatterjee, the question of accounts in a partnership business.
My lord, even in a kindly recall.
Produce that partnership deed.
Very well, I shall. My lord, only one thing, my lord, also remembers in a suit for accounts, simply it a suit for accounts. my lord, court can call for these documents by through 2611. My second prayer for account remains, even if it is said it's a partnership. This
All
would
right.
turned out to be a suit for accounts.
In course of hearing of this application, this court finds that
whether a co-sharer of a property can claim eviction against the defendant, making the other co-sharer a pro forma defendant. The other co-sharer is objecting, is not asking for a eviction. I made a prayer that since in view of this admitted fact, let there be a preliminary issue framed on this question whether in law can a co-sharer file a suit for eviction.
But for the purpose of deciding that, the factual aspect as to whether there are co-sharers is to be
That's an admitted position, my lord, in the play.
Let all the issues be decided.
My lord, this is absolutely frivolous, my lord. This suit can come to an end.
What is the stage of the suit?
Order 26 rule 9 will be heard. Order 26 rule 9 will be heard on the next day.
Issues have been framed.
Issue has not yet. We prayed for a preliminary issue to be framed on this question whether he can alone file a suit
The
against.
statement has been filed.
Yes.
What is the date fixed for framing of issues?
March 2025. 6 March 25.
So I'm keeping it in the month list, see what issues are being framed. If this is also an issue, otherwise the court has to be directed to frame this issue.
The court is minded to frame all the issues and decide the issue. Since this is a settled position of law, and the facts are admitted, this can come to an end.
Which provision of law you are trying to show?
Kelly takes order 14 rule 2. I'm relying on couple of judgments, where this is settled, that a co-share, is aware of order 14 rule 2, two issues, have to, there which can be, part of preliminary issue, 14 rule 2, A and B, where issues both in law and.
Only come to order 14 rule 2.
Yes, I'm reading that only, where issues both of law and of fact arise in the same suit. And the court is of the opinion that the case or any part thereof may be disposed of on an issue of law only. It may try that suit first if issue relates to jurisdiction of the court, a bar to the suit created by law.
So it's not with regard to the neither jurisdiction nor
maybe B, my lord. Kindly
disposing it of.
There is a bar, my lord. Kindly allow me to place one judgment.
Jurisdiction of the court.
Yes, institution on institution, my lord. May I cite this? Kindly consider this judgment. Kindly, my lord. 1996 6 SCC, my lord. Kindly consider this.
Do you want to come back after the issues have been framed?
I'm in my lord's hands, my lord, but the only thing, my agony will come to an end if this issue is decided, my lord. That was
Cannot be, because the question will be, show that they have admitted that they are the co-sharers, the others are not, they are supporting the tenant. Those issues are to be gone into.
Both these issues are admitted, my lord.
No, cannot.
Yes, I can show from the plaintiff.
Those, even if they are admitted, those are factual issues, not a question of jurisdiction.
Well, I'm not on jurisdiction. I'm on the institution itself.
That is the exception on which it can be decided, suit can be decided only on that ground.
Well, it can,
Order
only
14
considers one judgment. Well, I think I'm fully covered by this one.
Yes, yes.
My lord,
Show me that judgment.
kindly will it. Well, paragraph 37 of this judgment. 26 ada. Oh, 20 volumes. व्यक्त करो. Also frame that will frame an issue. To frame for that.
For hearing of petition on 26/9.
I should have shown the other judgment, my lord, but this is before my lord, on the left hand side, my lord. I wanted to show this one, my lord, 2020 volume 6 SEC, paragraph 60, my lord.
1996 volume 6, which paragraph you are placing? Paragraph 37.
37.
Which portion of paragraph 37 you want to rely upon?
Well, this is on the proposition of law, my lord, as pointed out, my lord, if my lord takes paragraph, third line of paragraph 37.
Yes.
As pointed out earlier, a co-sharer cannot initiate action for eviction. Cannot even initiate an action for eviction. This is what I humbly seek to rely
So
upon.
you will not read the paragraph as a whole. Come to just below class item C, starts with whether the premises which is in the occupation of a tenant
shall be retained jointly by all the lessors.
So this is a question of fact.
Well, if this is a position admitted,
So this is a question of fact.
but admitted, my lord. But
What
admitted in
Show
the
me the
plain.
admission.
Yes,
Show
in
me
the
the
plain, my
admission.
lord. In the plain, my lord.
Yes. Show me the admission.
Kindly takes, my lord, page number 21, paragraph 1 itself, my lord.
Yes.
At arbitral time, the plaintiff is a joint owner in respect of the entire premises number 99A, Bidhan Sharoni, KMC ward number, so within the,
Yes.
with the pro forma defendant. With the pro forma defendant.
Yes.
So, my lord, this
So
is
everybody is there. He is not claiming relief against that. So second part of paragraph 37, kindly come to that. Whether the premises which is in the occupation of a tenant shall be retained jointly by the lessors or they would partition in amongst themselves. They may agree to partition at any point of time. So this is a
partition
question of
suit is
fact.
pending, my lord. Between them, that's pending, and the defendant
Yes,
has filed
they may agree. At any point of time, they may agree for a joint partition.
But may I?
These are settled propositions of law. And you are trying to say that this has to be
bring an
decided.
end to this litigation, my lord, because this issue perhaps with the pro
Could
forma
not have-
defendant supporting
Because
me.
this is a question of paragraph 37, which you are stating, last part is against you. That is what I have told you. Just you will be reading only 2 lines. Judgment is to be read as a whole from paragraph 1 to paragraph.
Yes, my lord,
and
that's
this is
correct.
also not an order 14 rule 2. This is also not an order 14 rule 2. This
On the
does not say-
proposition of law, it's only. Well, there are other cases also, but my lord, if my lord is not mind, right, my lord, kindly, my lord, in that event, kindly, my lord, then waits, my lord, the court to frame the issue.
What is the reasoning on which it was rejected? Show me.
Yes, my lord.
Yes, neither involves. This is all. Rightly said.
My lord, kindly takes the last 3 lines of first page of the judgment.
Last 3 lines of
page 2 of the page 2. Well, that's the order dated 30th November 24.
Yes, yes.
And she does not have any objection to such construction, neither did she want the eviction of the defendant from the, that's the second pro forma response.
It's a different thing.
So the other defendant, the co-share, does not want my eviction. It's an admitted position that it's a joint property.
Take that point at the time of trial.
As my lord pleases. Expeditious.
Where is your application under order 14 rule 2?
Page 52, my lord.
7 is that?
Another aspect of the matter was there, my lord, they had claimed that I had made illegal construction. My lord, this writ petition was filed. It was, the court held it was.
Show me which issue you want to be framed.
Well,
To be
paragraph
maintainable under the law.
7, if my lord takes me.
Paragraph 7.
Yes, my lord. 7 and 8, my lord.
This application under Article 227 of the Constitution of India is
Me to the court.
You are a tenant, don't pray for that. Yes. Next, caller.
33, I am appearing the petition amended by Mr. Chaudhary. Yes,
Yes, Mr. Chaudhary.
Madam, the petitioner has filed an application for rejection of the claim. And I am drawing your lordship attention straightway to the order dated 27th November 2024, order number 15. Madam, kindly see the order 13th December for hearing under order 7 rule 11 CPC as a last chance. Next order, be heard out at any time. Next, be heard out at any time, at any cost.
So what happened on 14th of February?
I'm 29, page 29.
No, what happened on 14th of February? It was fixed on 14th of February.
Order sheet in page 29, downloaded copy. Page
Downloaded
29.
copy. Page 29.
Last chance.
All right, 5th of March it has been fixed.
I will be praying for an exceptional order for the reasons. This is the fourth
Application under Article 227 of the Constitution of India is at the Mr. Chaudhary, written objection has been filed to take up the hearing of the application
Written objection.
under Order 7, Rule 11 of the Code of Civil Procedure on the next date fixed, that is on 5th of March 2025, if the same is otherwise ready for.
Madam, kindly hear me for a moment. Madam,
yes,
in this matter, written objection has been filed. We have also filed our written submissions. And unnecessary delay is being made. Kindly just one thing I am showing.
What do you want? I have fixed the time limit for disposal.
Let it be disposed on 5th March or
cannot be on 5th March. Can be.
That is why I am showing just 1 minute time. But kindly come to the end of for a moment.
I have said as expeditiously, but preferably by the end of May. It can be disposed of on 5th of May.
Kindly hear me. Kindly hear me for 1 minute.
On a fixed date, it cannot be decided. I do not know the business of the court on 5th of March.
But
Yes,
kindly just kindly see the 1 minute time.
Yes,
1
Mr.
minute time, kindly. Page 14.
Yes.
Page 14. Kindly see page 14. A suit was filed in the year 2010. That suit has been dismissed. Kindly see paragraph 9. 5 deeds were disclosed in 2000.
Mr. Chaudhary, I cannot go into the merits.
No, I am not. Just for exceptional order, I am showing the conduct.
Mr. Chaudhary, on a particular date, an application cannot be directed to be disposed of. I will not
At least
pass that
within
order.
March. At least within March. Kindly see page now.
It can be, Mr. Chaudhary, it can also be disposed of on that date itself. I have fixed an outer limit. I have not said it will not be disposed of on that date. I have fixed the outer limit of May. Some leverage is to be granted. Nobody knows You may adopt a resolution on that date.
I'll see
Yes,
those
next.
5 deeds have been challenged in this suit.
Yes, yes. Call the next matter.
44. My lord, I am for the petition.
Get foot.
My lord, this is an application, my lord, against the judgment dated 3/12/2022, my lord, rejecting Order 7, Rule 11.
Rejecting Order 7, Rule 11.
Yes, my lord, they actually, my lord, we had come to know that after filing of the WS and at the stage of PH, when the documents had been produced, we have come to know that this is a Thika land. So, my lord, we had preferred this application for rejection of claim, and that was, my lord, rejected.
Plaint has been rejected.
Yes, Order 7, Rule 11, plaint has, no, plaint has never been revealed, but I am for the defendant.
Application has been rejected.
Yes, application has been rejected. Fact is this, my lord, the application has been rejected. Along with it, my lord, a 7-1 application which had been allowed by the court before, my lord, without any prayer, without any taking into consideration what they have said, my lord, 7-2 has been rejected. So, my lord, suo moto the...
I am expediting the hearing of the suit.
My lord, your lord.
Otherwise,
My lord, only one prayer. The last portion, my lord, of the order, that the order dated 3/12/23 hereby stands recalled. My lord, that was a 7-1 application which had been allowed. My lord, that, my lord, we want to pay. That is what I am saying. Only, my lord, this may be allowed, and my lord,
then you have to serve.
Lord.
Then you have to serve. Ashun.
No, my lord, lordship will dispose of, but let it not
If you,
be called
this is to be set aside, other side has to be heard. Without that, this cannot be set aside.
Well, there was no prayer. I have annexed the
All
document.
right, so you serve a copy, let them come.
Then, well, it will come again. Well, it will be automatically, well, it's
That is why, but it cannot be set aside without hearing the other side. Choice is yours. I can only expedite the suit.
I'm praying that let us pay. Let us, as we were paying, my lord, till
For that, they have to be heard. Without that, it cannot be allowed.
predetermined. They are saying we are licensee, we are saying we are tenant.
Some order has been passed in their favor.
Well, it's all right. I'm not saying, I'm saying, my lord, yes.
Some order has been passed against you.
Yes. So, my lord,
So they can take advantage of that order.
the orders against me. That is
Yes.
what I am.
So even if one is allowed, all right, but the second, if I set aside, they have to be hard. So if you want that, I can direct you to serve. This will be.
Then the suit is continuing, my lord. It's in the stage
That
of
is why.
permanent hearing.
If you want that, I will have to direct you to serve. Choice is yours.
Let it be speedy disposal. Let it be speedy disposal. Let it be.
By the application, no, by the this application under Article 227 of the Constitution of India is at the instance of the defendant
opposite parties. Your lordship remembers it's that matter, my lord, where the question failed whether a tribunal constituted under the Maintenance and Welfare of the Senior Citizens Act has the power to pass an order of eviction. That is the order which is under challenge, my lord, and he seeks to address your lordship on the propriety of the order. And my lord, I had
Where is the order?
But it kindly comes to the penultimate page of your lordship's brief.
Do you have the Senior Citizens Act?
Yes. Kindly comes to section
23.
23. Now, my lord, my
Give
submission.
me a minute.
Lordship.
Give me 1 minute. Let me go through the
Lordship,
impugned order. You are for the son and daughter-in-law.
No.
I am the son and daughter-in-law, my lord, they are the parents.
Why are you quarreling with your parents?
It's not a question of quarreling, my lord. If my lord, there is a very my lord, longish history to this. The daughter-in-law was tortured. She lodged proceedings under 498/34. There was a compromise. Based on that compromise, the proceeding was quashed. Thereafter, my lord, torture again started.
This
There
type
were
of
cases
litigation
come
should
again.
not come to court.
True. Very true. But my lord,
Since
this
both of
order,
you are there,
my lord,
can
the
you not
order of
see that-
eviction by the magistrate, subdivisional magistrate under the Act of 2000.
Give me the 2007 Act.
Lordship. Kindly see section 23.
এটা নেই বইটা আনিয়ে নিন section
23.
yes
My lord, it only deals with, my lord, cancellation of any
the gift deed.
gift deed.
If the gift deed contains the provision that he is to maintain, that provision is there.
This is not our case here.
My lord, here there is no question of any, my lord, any instrument being executed by the father-in-law or the mother-in-law.
So this is your point.
This is my point. And my lord,
Yes.
this issue has been settled. Kindly as a look at this order, my lord, passed by a coordinate bench of this court, that it has been held that the subdivisional magistrate does not have the power under the Act to order eviction.
My lord, I'll cite Supreme Court, my lord, the latest one, my lord.
No, Supreme Court, I will come. First, show me from the provisions of the 2007 Act that it has
Okay, my lord.
jurisdiction to direct eviction. Show me from
Under
the
section 23, there is no explicit provision, but it is implicit, which has been directed time and again by the Honorable
Except
Supreme.
in section 23, there is no other provision.
Yes. Now, my lord, the
Show me that.
purpose. Now, my lord, the purpose, my lord, if I may argue.
Show me the provision empowering the magistrate to evict a person.
Lord, may
Under 2007 Act. Show me that
Lord,
provision.
may I rely on this judgment? The judgment is.
Judgment will come after. Show me the
But I am
provisions
saying
of-
this, there is no explicit provision, but the interpretation of the law is that, my lord, to protect.
Show me.
Yes, my lord.
The judgment. I'm going to copy this.
হ্যাঁ, দিচ্ছি। Lord, I start with the latest one, then I'll revert back, my lord, to the parent one.
You need not. If you cite the latest one,
Yes,
you
no,
need
my
not
lord, there is
multiply.
reference of S. Bantia, my lord, which was at that point in time,
That was the parent decision.
parent decision. So, my lord, kindly takes up the 2025 SCC, and I'll be only placing the relevant portions. Lordship will kindly.
Show me which paragraph you are trying to rely upon.
Yes, absolutely, my lord. If pattern the point, then your lordship will consider
Yes.
paragraph 24. Before parting with the case at hand,
Paragraph 24, yes.
we must clarify the observations made by the impugned order over the competency of the tribunal to hand over possession of the property. In S. Bantia Supra, this court has observed that tribunals under this under the Act may order of eviction if it is necessary and expedient to ensure protection of the senior citizen. Therefore, it cannot be said the tribunals constituted under the Act, while exercising jurisdiction under section 23, cannot order possession to be transferred. this would defeat the purpose and the object of the act, which is to provide speedy, simple and inexpensive remedies of the elderly persons. So, my lord, here S. Bantia, my lord, has been considered. And this proposition, my lord, has been adopted by several high courts. I also rely on a judgment of the Punjab and Haryana High Court, my lord, which has actually laid down, which has actually given everything how it is to be done. Section 23 has been interpreted.
Yes, what do you say to this?
But kindly comes to paragraph number 3 of the judgment. What was the factual issue involved in this?
Maybe.
The appellant here
Obiter is also binding.
Lordship.
Obiter of the Supreme Court is also binding.
But here a deed of gift was executed.
Yes.
Now, my lord, the
But I am
appellant-
relying on the proposition. If I have
Excellent,
to
lord.
rely on the facts, my lord, let me finish first, my lord. On
All
facts,
right.
I will also come.
Take your seat. Yes.
But now, my lord, kindly considers another judgment, my lord, which is the reported in 2021 SCC online Punjab and Haryana High Court, my lord. Which not copy which. My lord, kindly takes it. My lord, this judgment gives an elaborate description of everything, what has to be done, how it has to be done. My lord, kindly considers onwards. Like paragraph 6, 5 and 6. Now that is on facts. 6 says the subdivisional magistrate in his report has recommended ejectment of the petitioners and had sent the same to the office.
Paragraph
6. This is on facts because he wanted me to draw your
yes.
lordship's attention on facts.
Yes.
The subdivisional magistrate in his report has recommended the ejectment of the petitioners and sent the same to the office of the district magistrate by order such and such, and has ordered ejectment of the petitioners from the house in question. Now, my lord, kindly have a look into the observations the court made. Also looks at paragraph 8, which is
This judgment may not be binding because there is a
yes.
division bench judgment of our High Court on
Yes,
this.
I know, my lord, Justice Mantha's done, but why I am citing
Division bench, I am saying.
yes. Now, why I am citing this is only
So
to
this
show
is a
that
coordinate bench of
leave it
another
for lordship.
court may not be binding, but you have cited the Supreme Court.
Yes. Now, my lord, you can also cite why I am citing this is for the
Yes.
purpose how is to be done. There is no explicit view expressed in the Supreme Court's judgment how it is to be done. Kindly considers now, my lord, last paragraph, my lord, paragraph number 14 onwards, which is the procedure for eviction from the property, and then, my lord, the eviction. It is categorically stated what
In
is
the rules.
yes. And also, my lord, in this judgment, in paragraph 16, it is clearly clarified that a perusal of the above provisions would make it explicit. My lord, I use the language explicit. There is a provision for eviction in the 2007 Act. Besides the instant, it is not a case where any transfer of gift has been executed, which my learned friend was trying to harp upon, by the respondent number 4 and 5 in favor of the petitioners. Thus, the petitioners cannot maintain their claim on the alleged ground that
Here there was any deed of gift.
nothing. I am the absolute owner. My lord, I will show from the FIR how cunning this lady is. She files an FIR under 498A only against the, my lord, ailing, aged senior citizens who are his father-in-law and mother-in-law, exempting the husband. Looks at the conduct. I will show the FIR
So
from.
if there is no gift deed,
Yes.
whether a proceeding under section 23 is maintainable before the subdivisional magistrate.
For protection, can I not seek only protection? Can I not seek protection of my possession?
All those where gift deeds were there.
No, not always.
All the Supreme Court's matter also gift deed was
Gift deed is something, is one part. There are two parts to the provision under section 23. There are two parts. Either there is a gift deed, I give it to my son refutes and then he throws me out or tries to throws me out. Then I am protected. But what about the second provision where I have a right in respect of my property, which is self-acquired, and my son does not maintain me, and on the contrary, creates an harassment. I'll show, my lord, if your lordship calls upon me, I'll show from the records. I'll just refer a short supplementary affidavit. My lord, I have the list of dates to indicate how many criminal proceedings has been initiated by them.
Whether I am only on the jurisdiction part. I'm not on the merits.
Yes, my lord. Supreme Court has categorically said to amplify. But I would rather use this word amplify. Why?
Show me how it has been. Show me the reasonings why eviction was directed in the impugned order.
Kindly sees, my lord, with my deepest, my lord, respect, my lord, I would say, But to some extent, they have admitted themselves to leave the
No, no,
premises.
show me the eviction order.
Well, kindly see, that's the impugned order, my lord.
Yes, the order dated 2nd of June 2022.
Yes.
Yes, show me where it has been said.
Lord, kindly
What is
look-
the finding in support of that?
my lord, he has proceeded on the basis of the pleadings and because the procedure is, my lord, I contend, because my application was under 23 only seeking eviction and protection. That was the scope of my application because there was no gift deed. Here, if
So
you
show
look-
me that eviction was directed by this order.
But here, my lord, it is kindly construed this in way. My lord, they said,
I'm asking you, show
yes, my
me,
lord, they had,
show me
they
the
had-
line directing eviction. Show me that.
my lord,
in the
kindly
impugned
see,
order.
my lord, we'll leave the house. My lord,
Where?
they have portrayed it. My lord, kindly see, the opus, Srimati
Both
Kakuli says-
show me, you can place the entire because this is a short order. You can place from the beginning.
There's only two things to place.
Yes, yes.
During the hearing, it was known. My lord, first thing, requisites have been followed, notices have been given. Both
Not on
parties
that.
were heard, principles of natural
Yes,
justice
place,
were
place
followed.
the substantive portion of the order.
The
Yes.
petitioners did not claim for maintenance. He prayed to evict his son and daughter-in-law, OPs from his house as they disturbed them a lot mentally and physically. The OP, Srimati Kakulide, is expecting mother, showed a desired time till delivery of the child. So, my lord, this,
They prayed for time.
they prayed for time.
Yes.
Time
Next.
was also granted.
Proceed
Yes.
further, sir.
And then they will leave the house. So, they voluntarily accepted.
Yes, that was their statement.
Yes.
Then show
Both
me
the
that
parties
there was,
submitted their deposition informing that they will not be involved in any kind of quarrel regarding the said matter. Now, my lord, it is ordered both parties are to keep peace and tranquility at their home. Considering the medical ground, the OPs are directed to leave their house. My lord, this was
so
considered.
where is the finding that he was being
Medical-
disturbed? Show me the finding that they were being disturbed.
Lord,
Show
that
me here.
finding, my lord, then I have to
No finding.
rely on a supplementary
No,
affidavit
no,
to
no,
show.
no. You cannot improve
Lord, he
upon that
cannot-
order. No
Lord, he
finding
might
is
not have
there.
explicitly said, but my lord, medical grounds he has said. And my lord, numerous criminal cases being lodged by the daughter-in-law against the parents. Not the
Medical
husband.
ground, the Honorable Supreme Court did not say for that ground eviction can be passed.
Lord,
Show
for
me that.
protection. Because my lord, if I am medically unwell, kindly appreciates one thing, my lord. If I
Show
am,
me that. On what ground eviction was directed.
but here are,
To ensure protection of the senior citizen.
yes, so ensuring protection.
Where is that finding?
But if I am, kindly appreciates, my lord. If I
There
am,
is no finding.
if I am
I
unwell,
can relegate it to the magistrate to decide on that issue. No finding on that.
remands it back to,
That is one
Yes,
thing.
yes.
First, I have to decide on whether you are ready with the maintainability issue today or you want time
I am
to.
ready with the maintainability issue today. I am ready. Let him argue, but I shall.
Yes. How long you will take?
I leave it to your lordship. I can come back also, my lord. If,
I'm asking
because
you. how
I
long-
want to rely on certain papers, my lord. Just to
That
indicate.
is why I'm asking you how long you will take. That is
I'll
why.
take 5 to 10 minutes more, my lord. Because those papers have to brought on record. Just because this is on facts as well. Because, my lord,
Papers
he
that you
has
brought-
given
so
a
you want to
protect.
file any supplementary affidavit?
Yes, just to bring on record how many documents, my lord,
All
have
right.
been suppressed.
The learned advocate appearing for the opposite party
my lord, there's another application which is for vacating, my lord, which is still pending.
In view of the aforesaid order, the application for extension of interim order and the yes, whose book is this?
My lord. In the month list of April, my lord, let it appear fairly at the top because, my lord, I want.
It will appear. If it does not appear, you
Kindly understand the predicament of the parents, my lord.
I appreciate. Nothing will happen. The son and the daughter-in-law will stay with you.
They are.
Nothing great will happen.
I am willing for them to stay,
as
but
a actor,
situation is as such. But
Then
let them
you
have an
have not
undertaking.
to disturb, harass.
Kindly puts one line, my lord. Otherwise, my lord, they will take it as a.
The petitioner here in
Mulad 36 appear for the petitioner, the defendant petitioner. Mulad had the occasion to hear this on the last occasion. Mulad recall this is a suit for eviction at the initially at the instance of a life interest holder, arraying the beneficiary under the will as a pro forma defendant. The pro forma defendant was thereafter transposed in terms of an order dated 16th of 11/2022.
yes.
Thereafter, taking advantage of the order of transposition, files an application under section 151 with intent to have her husband deposed.
Petitioner was the life interest. No, petitioner's predecessor.
Yes, the plaintiff was the life interest holder, and the beneficiary was the defendant number 2, pro forma defendant, the benefit under the will.
At that point of time.
At that point of time,
He filed a suit for eviction.
Eviction.
He or she? She filed a suit for eviction.
Under the will.
Against Mr. Chakraborty's client.
Under the will, the original plaintiff was the life interest holder and the pro forma defendant.
She died.
And the pro forma defendant number 2 was the legatee of the beneficiary. Now, the life interest holder died in pendency of the suit.
You got yourself transposed to the category.
I am the defendant.
Yes,
Defendant
you
number
are.
1 tenant. I am the defendant number 1 tenant.
Oh, you are the tenant. I thought Mr. Chakraborty is for the tenant.
So, now what happens is.
So, Mr. Chakraborty was transposed to the category of the plaintiff.
BD an order dated 16th of 11/2022. Now, after being.
Now, what happened after that?
After being so transposed, this present plaintiff files an application seeking to have her husband examined at her behest in her place and stead. Whether that could be permissible in view of the fact that the husband originally
deposed on behalf of the mother.
The mother.
As PW1.
Yes, well, there's a difference. She was cited as a witness on behalf of the plaintiff as PW1. Now, what this present plaintiff wants to do, this application is premised as if the husband will depose as if the husband is the plaintiff. Kindly seize the application.
Mr. Bordon, after transposition, any additional grounds have been made out? Nothing. So, Mr. Bordon, only this fact will come. So, according to you, he has to be recalled.
Yes. And the issue is he cannot depose in the manner sought for. Why I say, but kindly
but Mr. Bordon, he can be recalled and deposed.
Because what happens, I'll tell you the reason why
I will clarify that.
Why I oppose this. Because
I will clarify that. Let him depose.
Yes. Because what is happening now is the present plaintiff does not want to step into the witness box, saying, kindly seize the application. Seize the application for once at page 131.
It's better, Mr. Bordon. One who deposed, his evidence is already there. So if he deposes by recalling, what is the harm?
No.
Because the same person.
I am not on the issue of recall. Today, what I am on is this application as has been filed and the evidence that has been sought to be tendered is as if the present plaintiff is deposing. These will be considered to be the statements made by the present plaintiff. Now, the issue today is the husband of the present plaintiff cannot bring on record, those averments. Kindly seize, the application at page 131 and then, the examination.
Application at page 131. Yes.
Now, this application, my lord, is premised, kindly takes up when page 132, is premised as if this order 109, my lord, permits this application. My lord sees it. Now, my lord, kindly takes the trouble of coming to page 75, which is
What is 109?
109, my lord, is the order at page 75, which was the order of transposition.
Oh, that was the order of transposition.
Yes. My lord, kindly see
Page.
the order of transposition.
Page.
Starts from page 75, my lord.
So, Mr. Bordon, you come at 2 p.m.
I'll come back.
75. How much time it will take?
10 minutes, my lord.
10 minutes. Mr. Chakraborty?
2 minutes, my lord.
Yes. এটা 2 p.m. আছে এইটা হয়ে যাওয়া এটা কন্টিনিউইং হ্যাঁ কন্টিনিউইং টা আগে
I'm just preventing them because suit was started in 2013. Reasonable requirement. Successfully. And they are again fighting.
successfully dragged
Successfully.
till 2024. Now he is trying to drag it further in 2025.
Argument stage, 7 dates were there for argument. That stage.
Someone died.
That's the stage of argument.
Someone died.
Yes.
Someone died.
Good player. Very good player.
Not mine. Almighty's. Someone dies, that was not within my hand. Not within my control. I'll come back.
Yes.
Item 136, continuing matter.
My lord, we take up page 131, that's the application, my lord. Pursuant whereto, my lord, the impugned order was passed.
131.
131. My lord, sees paragraph 1 at page 132. The entire application is premised on the order dated on order number 109, which appears at page 75. My lord, this application, my lord, kindly sees in terms of the observation made, be the order dated such and number such and such. Your petitioner has tendered evidence today through her husband since he is competent to tender evidence on her behalf as per provisions contained such and such. Then, my lord, kindly sees para 2, aged 64 years, various ailments, becomes frequently unconscious because of ailments under constant treatment. Then, my lord, para 3, she is not in a position to face the stress of examination and cross-examination. Then, my lord, kindly sees paragraph 8. In view of the direction of this learned court, your petitioner has agreed to tender further evidence through her husband, who has been authorized by the statute to depose on her behalf.
Yes.
And the order on purported reliance whereon, my lord, this application has been taken out appears at page 75. My lord, that, in my most respectful submission, my lord, is an order merely allowing her to be transposed. This order does not confer any right upon her to prefer this application. And in fact, this application is premised as if this order is the
that order permitted.
Yes. So, my lord, then, my lord, kindly sees what is the examination. The examination, my lord, I handed over the last petition, my lord. What does he want to tender in evidence? Let's got it, my lord. Further examination, chief.
Yes.
Lord, kindly sees page number 2. On behalf of Joyce Kaur, who is my wife, however, the plaintiff being my wife, has authorized me to adduce evidence on her behalf in this suit. I have filed the said letter of authority. This is, my lord, as if the plaintiff is stepping into the witness box. This is the application, my lord. I say, my lord, this cannot be permitted. I say, my lord, this cannot be permitted on two false scores, my lord. One, the order on which she relies, my lord, to make this application, that order does not empower her to make this application.
So according to you, plaintiff cannot authorize her husband to depose.
No, what I say, my lord, is this thing. The order number 109.
That is one thing.
One thing. Number 2, the plaintiff cannot authorize her husband to depose in a manner as if she is deposing. So this evidence cannot be construed as if the plaintiff has stepped into the witness box. This is what the gamut of the application and the evidence is. The plaintiff is trying to bring the husband to show that the plaintiff has herself stepped into the
Not the husband depose on behalf of the wife.
Can. But, my lord, here is a case where what does she say? The husband could have been cited as a witness on behalf of the wife. There's no qualms on that. But here, my lord, the plaintiff intends that the evidence of the husband be construed as her evidence. This is where the problem is, my lord. Because the letter of authority.
Yes.
The letter of authority on purport reliance whereon, my lord, this evidence has been filed, examination has been filed, my lord, would lend credence to the fact that the plaintiff wants this to be her evidence. And not as an evidence of a witness cited on her behalf. So this evidence, my lord, in my most respectful submission, should not be construed as an evidence of the plaintiff. Kindly cease, my lord, thereafter. I say my father, Khetra Mohan Kaur, have been the owner. So this is basically the evidence of the wife. Kindly takes it thereafter, father's last will, my mother.
Mr. Gordon, let us take a hypothetical case. Wife authorizing the husband to depose on her behalf. As plaintiff's witness.
Yes.
Let us assume that yes, he had also she is the plaintiff. So can it not be done?
Can be done. But this evidence cannot be construed to be the evidence of the plaintiff. It can be construed as an evidence on behalf of the plaintiff by a witness cited by a plaintiff. But this cannot be construed as if this is an evidence of the plaintiff. Why, my lord? What happens is the plaintiff now, under the garb of this application and this affidavit on this examination.
What is the difference in the effect of these two?
Yes, my lord. Why I say so, my lord? Kindly sees, my lord, the impugned order. Not the impugned order, my lord. Kindly sees the order dated 109.
109 is only transposition.
Yes, my lord. So this application today, which they have preferred, and in fact she has preferred, is on the premise that this order.
Yes, that is one thing.
So can that be permitted?
Yes.
So can that be permitted? Can this application be permitted to be an application filed in terms of the order dated 16th of November?
109.
109. That's my first contention. Second is, my lord, the plaintiff must step into the witness box to prove her case. Here is the case where the plaintiff comes before the case court and says she is not in the position to face the stress of examination. And, my lord, the facts of the case is that, my lord, when initially the original plaintiff was alive, my lord, the same gentleman deposed as the PW1 on behalf of the original plaintiff. So, my lord, what is the plaintiff trying to do? The plaintiff is now trying, my lord, to not step into the witness box under the
avoiding to face cross-examination.
Yes.
I follow your argument.
This is what I'm on, my lord. So this evidence cannot be construed to be the plaintiff's evidence. That's, my lord. And number two, my lord, number three, my lord, the application as it stood before the learned judge in the court below, in these premises, my lord, ought not have been allowed. There was no application under order 18 rule 4. I would have still understood. Kindly sees the purport of the evidence.
Yes.
Well, let's see in the examination in chief, my lord. It's as if, my lord, the plaintiff is tendering evidence. This is precisely what I'm on, my lord. These are my submissions.
Any provision you want to rely upon?
No, my lord. 120B doesn't get attracted out here.
And what is the judgment which you relied upon?
That is not very material.
That may go against you also. Do you have the copy of the
I
judgment?
don't.
You relied upon that.
I don't. My lord, kindly sees it. If my lord has it, I'll check it out. But doesn't support my case.
But it may go against you.
I'm not very sure. I'm not very sure.
You can place that.
I'll just
may not be supporting you, but if a decision which was taken into consideration goes against you,
probably not. So I'll just take a moment to plan out. This is 2019 volume 4.
Yes.
MPLJ
461. Do you have a copy of that?
I don't think so.
Yes.
I have it. This is probably not on the point.
Yes. Yes, Mr. Chakravarti.
My lord, I will show you one line from the order dated 16th of November 22 at page 75.
Page 75. Yes.
109, order number 109. One line. Come to page 76, my. Come to page 76, last portion. Last paragraph.
Yes.
But third line from the bottom. But that has to be established by adducing evidence by the petitioner.
Page?
Page 76, my lord.
Yes. Which paragraph?
Page 76, my lord. Last paragraph. It is starting moreover. Just before that,
Yes,
my lord.
moreover.
Moreover. Come before that, my lord.
Yes.
Khetramon Court, fourth line, fifth line. This
Yes.
petitioner has become the landlord owner in respect of the suit premises against the defendant. But that has to be established by adducing evidence by the petitioner. So the trial courts of the view that eviction suit, ownership has to be proved, which is erroneous view, my lord. This line created all the problem. That I am to prove my ownership. Title deed, everything was produced, exhibited. But court observed that he should give evidence. Probate is there. Everything is there, exhibited. Only relationship of landlord and tenant has to be proved in eviction suit. That is the view of the apex court. Only relationship.
The 56 Act, 56 Act, reasonable requirement, ownership has to be proved, but not under the 1997 Act.
That's why I say, forget that. It is 97 Act. I am suffering from 2013, I told you. I want to get rid of right now. Because point is very small. Then we made an application. That husband will depose.
You made an application, husband will depose. Where is that?
Well, that is the last application my friend placed before lordship.
Page 131.
Page 131.
That is the application.
Yes.
Husband will depose.
Yes.
151, my lord. Now, my lord, kindly see the impugn order.
Yes.
That has not been placed. That should have been placed before lordship. Where is the jurisdictional error by the court?
Yes.
From the top, my lord, kindly see. Today is fixed for passing order in respect of petition dated so and so. Skip that portion. The petition dated 21st August 2024 contemplates an order permitting Amit Kaur, who is the husband of the present plaintiff, to adduce evidence in terms of order number 109 dated 16th of November 2022. It was stated by the said plaintiff that the petitioner is aged about 64 years and is suffering from various ailments for which she is under constant treatment and supervision of doctor. For that reason, it is not possible for her to face the cross-examination. Apart from that, she has also lost her ability to remember any day-to-day incident. It was further submitted on behalf of the plaintiff that on the strength of the provisions of 120 of the Evidence Act, the husband is competent person to tender evidence on behalf of the wife. While raising the objection against the prayer, the plaintiff, it was submitted by the learned advocate defendant that the husband of the present plaintiff is not at all a competent person to adduce about the reasonable requirement of the plaintiff. Apart from that, the husband of the plaintiff tendered evidence on behalf of the present plaintiff, but would not be in compliance with order number 109 dated 16/11/22. It is their submission. The evidence of Joyashree Kaur in person is necessary as she is the only person who knows the real facts. Pardon, proof is me. I will prove my case. Why you are so nervous? I will prove my case, my lord. Then no medical documents have been filed in support of the contention regarding ailments of the present plaintiff. There is a provisions for commission. Now, my lord, their actual submission was that I ought to have taken an application for commission. Whenever an application under arbitration is taken up, my lord, there it is bound and duty to prove that what is the inability of the witness to come. It is not a case for inability of the witness. Here, if we say that she is fit, well, she can legally avoid. She can legally avoid because law has permitted her to be represented by the husband. Husband can come here. So that plea cannot be taken here. They have taken that plea also. We have not applied for that. They say you apply for that. If you are ill, you apply for that. Commissioner will go to the resident and then she will be examined. Here you have said that she cannot take the stress. She forgets everything. But the last portion is very important, my last portion.
Yes.
Just 10 paragraph. The evidence is already completed in the suit. And it is on the verge of disposal.
Which place?
Sir, first
Evidence,
page,
yes,
right?
I've got.
First page,
I've got.
Yes.
Yes.
Evidence is already completed in the suit and it is on the verge of disposal as the matter was fixed for argument before the defendant raised jurisdictional issue. It is the suit of the plaintiff and the plaintiff is the dominus litis, what I am submitting right now to your lordship. Then thereafter the court says originally the original so and so proved, and then the court said if how far the ground of reasonable requirement has been proved by the evidence adduced by the constitutional attorney of the original plaintiff, that will be decided by the court at the time of final adjudication. The petition dated so and so filed by the defendant contained the prayer for direction upon Joyশ্রী court to adduce evidence regarding ownership in terms of order number so and so. That petition is allowed by this court. So the present plaintiff Joyশ্রী court is not supposed to adduce any further evidence except the ownership in respect of the suit premises as required by order number 109. The court was repeating that because that portion I said, this is no more required. We didn't challenge the High Court. That's the problem.
Yes.
That order ought to have been challenged by us. Then, my last paragraph, kindly see. Last paragraph.
Yes.
Last paragraph after fourth line. The order 18 rule 4 of the Code of Civil Procedures have to state that he is giving statement in capacity of a husband.
That is relying upon that
is,
MPLJ.
Yes. Therefore, is competent witness to give evidence, not as plaintiff. Where is the jurisdictional error, my lord? What is the error rather? One further round is there. We have enjoyed that. But let not the suit be dragged once again, my lord. Everything is there. And court said at the time of argument also, the scope is there, you can argue that point. But why this will be again deferred, my lord? That's my only point. Technical point.
Yes.
Hyper-technical point. And if I hold the brief of defendant office, I will become hyper-technical. I will change my.
May I respond? Short response. Probably I was not articulate enough. My issue is not with the evidence. My issue is only on the fact
who is competent to give that evidence.
Not even that. I am on a very preliminary issue. This evidence of the present Amit Kaur should not be construed as the evidence of the plaintiff. Because what the plaintiff wants now is to avoid the rigors of cross-examination and at the same point of time have the evidence adduced by her husband to be construed as her own witness.
So Vardhan, rely upon this judgment because these were considered. You rely upon this judgment. Because these points were considered.
Yes, it was considered, yes.
Yes. So this is also a point that regards of cross-examination
But I thought this was too well settled.
26.
But I thought it was too well settled.
The constant judicial appeal is that if a party abstains from entering the witness,
yes,
it would give rise to an inference.
That is a very well settled proposition of law. That is probably not, this judgment is probably not required for that. And especially in this court.
But paragraph G is against you.
I am precisely on this. See, you can depose, but your deposition cannot be construed to be the witness of the plaintiff. These are my submissions.
I will give ultimately a direction, my lord. Otherwise, I will again have to come. Give a direction for conclusion.
And the earlier order which my learned friend was relying upon,
direction for conclusion.
that has been challenged at my instance.
That's the argument stage.
Argument stage. Kindly give a direction.
That part, the
unending.
The order we were relying upon, that is already under challenge before this court at my instance.
No, I could not follow.
This order of 16th November is
that 109.
Yes, that is already under challenge at my instance, not at their instance. They have not challenged, so they have accepted the order as it stands.
Yes.
So if they have today,
they cannot challenge because their pair was allowed. How can they challenge, Mr. Vardhan?
No, when I challenge, it was open for them.
That is cross objection.
Yes. So since my lord, a revisional court, my lord, is a part of the appellate jurisdiction, my lord, the principles can be borrowed, my lord.
Cross objection.
Yes, and
Not
that
a-
was
Not a fresh revisional application, cross objection.
yes, precisely because I had filed a CO.
Cross objection for which portion?
My learned friend was relying upon that, saying that this portion was not correct.
Ownership.
Yes.
He says that that may not be required, but he's since the order directed him, he's taking that plea. So he's not challenging that. He says though he is not required under the law to prove ownership, but since by order 109 he has been directed, he is giving this evidence.
But may I pose the question to myself? Does this 109 empowers him or puts similar to any and sort of right upon him to prefer this application? That's the question, my lord.
Let me now decide.
All right, I'll leave it to Lord.
This application Yes. Yes. Have you got that copy of the application?
There is a mention in the order sheet itself
Yes.
about the order. My lord, what I have gathered from the last hearing, that your lordship has been pointed out that we have violated the stay order granted by in the earlier.
That will be I will, when I decide the matter, I will make that. I'm asking you, on what basis this order dated 18th of February 2025 was passed? Show me the basis of this order. Why this order was passed? Who invited the learned ACJM to pass this order?
This has been the extension application has been filed
Show
by
me that
bank.
extension
That
application.
application could not be forwarded to
So
the learned
that
advocate.
application was filed for
Application.
extension of the order directing possession to be handed over.
No, this is the extension to execute the section 14 order.
Yes.
Yes.
So when that application was filed?
That application was filed on 18/2/2025 itself.
Could you file that application on that date? I'm asking
Yes,
you.
now, kindly. Kindly come to that order.
Yes.
It has been mentioned, the third line, about the order passed dated 6/2/2025 by this honorable court. So there is no suppression. Now what is?
I'm not on suppression.
No. What was that order? That stay order. What was that order? Kindly come to. Yes. Kindly come to they have not paginated the last portion, that is the order dated 6/2/2025.
6/2/2025.
25. And the seventh paragraph.
Second paragraph.
Seventh paragraph.
Yes.
However, since this court had admitted the revisional application, the interim order passed. Let the interim order stand extended for a period of 2 weeks. The interim order that was passed earlier. Now, what was the interim order passed earlier? I am asking myself. Kindly come to the earlier order. That is before that order, 6/2/25's order. Just the previous page.
Yes.
Kindly come to the para 5. Para 5. Pending hearing of the aforesaid application, there shall be a stay of possession notice. This is very important. There shall be a stay of possession notice dated 17th of December 2024. 17th of December 2024. Let us go through the 17th of December 2024.
Page 99. At page 99.
No, তার আগে আছে। 17th of December 2024. It is at page 132.
Page 132.
132. It is in my petition. It is 132. It is in their petition.
Probably it would be 99.
A lot of regulation.
এইভাবে হয় না।
আমাদের voting নেওয়া আছে।
এইভাবে হয় নাকি?
I have through mail have sent.
Separate regulations are needed.
99.
There are many page numbers, Mr. Pal. What have you done? 132, 97. Yes. One thirty-two.
This is 132. That is the date of 17th December 2024. My lord, I am coming to the second paragraph.
Yes.
Accordingly, you are requested to vacate the below mentioned property on or before 25th 12/2024 and shift all your movables movables therefrom, as I will take possession of the property. So this is actually a notice for taking physical possession. I have not, my humble submission is that I have not, till the subsistence of the interim order, that is stay, have not affected physically to the petitioner. So far as the extension of my section 14 period is concerned, that is in respect of possession notice dated 12/6/2023. This letter cannot be said constitute to be possession notice.
Which page?
This 17/12/2024 cannot be constitute to be possession notice.
Why?
Because
you have indicated possession notice at the top.
The possession notice means the notice issued under section 13(4).
That is not the, you have said possession notice.
So far as the connotation is concerned, so far as the meaning and purport of this letter is concerned, the Honorable Court has restrained us not to physically evict the petitioner from the secured property till 20th. Till 20th, we have not done anything to his occupation. Now, they have already filed one IA, that is 4988. So, they have already gone to the DRT. The issue is squarely coming within the jurisdiction of the DRT. They have not annexed here with the IA application, but they have later issued a letter, that is they issued the 4988 before the.
You have received the copy of the IA. IA receipt.
IA receipt.
Do you have a copy of that IA?
No, they have not served it.
You have said you have received, you are saying they have not.
No. It is with the bank. Bank has not yet handed over to us. This is a separate set of advocates.
Bank has been served with that.
Bank's advocate has been served with that. So, therefore, this is one.
So now DRT is in Sisin over the matter.
Yes. On
application has been filed. So 227 should not be entertained.
There is a judgment. Should I
Yes.
place? When there is an alternative remedy, my lord, that alternative remedy has to be exhausted at page 7, paragraph 17. বলছি কপি আছে এটা হচ্ছে আমি দিয়ে দিচ্ছি 2022 ভলিউম 10 SCC 477.
This is order 9 rule 13.
Yeah.
Why are you bringing order 9 rule 13? There are judgments on Sarfaesi Act itself. So produce the latest judgment 2024 volume 6. That is the latest judgment on Sarfaesi. Why are you bringing this alternative remedy on order 9 rule 13 when there are plethora of judgments in Sarfaesi? Latest one 2024 volume 6.
That judgment is not with my brief, I think.
That will be relevant.
That is relevant.
Because
and yes.
You have got that judgment?
Not now. Not now, my lord. It was in, I think, other. On the previous.
According to you, existence of an alternative statutory remedy is a bar. Is a bar. 227 cannot be entertained. That is the proposition you are trying to canvass before the court. 227 cannot be entertained under
My lord,
any
when-
circumstances.
No, under any circumstances.
So,
No.
There are
here-
certain exceptions on that. What are the exceptions?
If it is material irregularity is there. In this case, there is no
no.
material irregularity.
Other exceptions, you are well acquainted, you are appearing for the bank. What are the other exceptions where 227, 226 can be entertained? Even if there is alternative efficacious remedy, what are the other exceptions?
If there is any gross violation of the order. But in this case, that has not been
That is
taken
on
place.
fact. So
In this case-
227 can be maintainable under certain
Under
circumstances.
but in this
Thank
case,
you.
that has not been violated, my lord.
That is on merits.
And
That is
they
on
have
merits.
already gone to the DRT. So that's why I think this.
What is the date fixed before the DRT?
27.
So you could not wait till 27. You could not wait till
No, that has
27.
not- No, that is the ACA application fixed for 27. This IA application has. They have placed for, they have prayed for fixation of the same, but that has not been fixed.
You took that advantage.
My lord, this is public money, my lord.
Yes, yes. Anything more?
Okay.
What have you done with the property?
This is in our position now. This is in our position now.
Ashok.
if the law permits, then they can later on proceed from this position, that from this position notice and section 14. They liberty be given to the bank to proceed further.
Yes,
from
yes.
this, yeah.
Proceed further. DRT, if the matter is pending on 27th.
If that be recorded.
Yes, yes, yes. That will be
That
recorded, but provided you give the time when you will hand over. First hand over possession, subsequent to that, everything.
Otherwise, if that been.
Yes, yes. That I will protect. So that should have been the stand yesterday. That should have been the stand yesterday. You took the court very lightly. You thought that once possession is taken, everything will be over. Come with the instructions, then I will make that observation. Yes.
26. My lord, appearing on behalf of the petitioner and defendant.
Yes.
Well, the defendant, the plaintiff opposite party has instituted a suit against the petitioner defendant for eviction of tenancy.
Section 57172 rejected.
My lord, kindly.
What is
argue
there?
my case, kindly permit me to argue my case. What is? My lord.
Whether you have filed, answered one or two questions.
Yes, my lord.
Whether you have filed 7172 within the time limit.
8 days.
Yes or no?
No.
In one word, no. So you have filed that application along with section 5.
Yes.
Whether section 5 is maintainable in 71 and 72.
My lord. That is a mistake on the part of the advocate, my lord.
Maybe.
My lord.
I'm asking you whether it is maintainable.
Yes.
Mistake on the part of the advocate, advocate's clerk, other things are on facts. I'm asking you a question of law, whether that is maintainable.
My lord, section 5 of the 7172 is as per maintainable.
Is maintainable.
My lord, one thing, my lord.
Where are the Supreme Court judgments? Where is the division bench judgment of our court?
Well, I am placing before the two
Devashish Pal's judgment. Where is that? Delivered by Honorable Justice Sanjay Kishore Kaul.
I have
As
placing
his
before
lordship
the
then
two
was.
judgments. Bahadur Singh Khaturia and Calcutta Gujarati Education Society, my lord.
Judgment delivered on
2023 and 2019, Justice Rajasekhar Sharma.
It has been held what?
Extension of section 5 lie and extension of time may be granted, my lord.
So this was referred to a division bench. I'm asking you, where is the division bench judgment? This was referred to.
Yes.
Framing an issue. Where is the division bench judgment?
My lord.
Decided over by Justice Sarkar.
That I'm not produced. My lord.
Question has been answered.
My lord.
By the division bench of Justice Sarkar.
My lord, the statute is specifically well settled that the 7.
Sir, you have not brought those judgments. You are citing a judgment wherein a matter was referred. This reference was answered.
I am seeking time for time. My lord, seeking for time and placing the judgment tomorrow, my lord.
What judgments will place tomorrow?
Division bench judgment I will place. Well,
You are aware, you are bringing this judgment.
My lord.
You have brought this judgment.
But
You have undertaken some research. You have brought that annotated book.
My lord, I have the judgment. But the section 5 lies that the section 5 of the limitation is attracted when there is a delay in making the
Subrata
application.
Mukherjee's judgment. That is Subrata Mukherjee's judgment. From where you are placing?
My lord.
Is it the judgment of Subrata in the case of Subrata Mukherjee? Give me the book. Give me the book.
Section 4.
Which page you are placing?
$551.
551.
That side. That side.
Left side.
Yes, my lord. Second paragraph.
(2009). Position has changed.
Well, statute.
Very damaging judgment, Devashish Pal. You have not
Well,
considered
statute
that.
provided that having regard to the circumstances of this case, an extension of time may be granted by the civil court only once and the period of the extension
Sir,
shall
that
not
is
exceed
after an adjudication is made under section 7(2), court fixes a time, one extension can be granted. But 7(2), not section 5 in 7(2) is not maintainable.
Well, court has to be adjudicate 7 and 7(2) without section 5 application, my lord.
Yes, yes.
My lord, the authorized officer is in another location and the agency is another. So the key is with the agency. My lord, the authorized officer requested to submit if it be tomorrow by 12. Tomorrow latest by 12. Before 12 we will.
Today at any point of time.
Will not see things. But
Today he has gone to take possession. Today he has also gone to take possession anywhere. Where he is now? In which location?
That I
just informed that
another location.
24 Parganas. It's around North 24 Parganas.
Not 24 Parganas. And this property is?
South 24 Parganas.
Behala.
Behala.
Behala. And not 24 Parganas where? Which location?
But he just stated that he is in North 24 Parganas. He just specified the area actually.
His office also is North 24 Parganas, Rajarhat.
Rajarhat, that is it.
It is his office. Agency is doing all these things. Just now he said that agency, lock and key is under the agency.
ওটা করে কোথায় আছে? On or before 10:30 AM tomorrow. He can come early, start early, come, give possession to 10:30.
And the liberty I.
কালকে ডেটটা দিয়ে দিন। 10:30 tomorrow to stop. List this matter tomorrow under the heading to be mentioned. আচ্ছা ওটাকে করে দিন as paid for by the learned advocate for the opposite party. The time is fixed as paid for by the learned advocate. Yes, next.
I-58. But I am for the petitioner.
Five.
Eviction suit, between the brothers. I am the younger brother. I am the elder brother. Younger brother is the plaintiff. In that,
What is the urgency, Mr. Lydie?
27th is the date, my lord, and it is being argued. Kindly comes to page 37 is the impugned order. My lord, my evidence has been closed as I was
Why
not.
your evidence has been closed?
As I was not able to, my lord, go and my lord, go there in view of the fact that I was operated. And my lord, this operation was, my lord, of retinal discharge, my lord. I have annexed the medical documents before the court also. Kindly takes note of the first paragraph.
Started?
Yes, argument started. We had, my lord, pointed out that your lordship, I have the orders also. Plaintiff argument started. Well, next date is 27th, my lord. The court did not adjourn, my lord. Once it was adjourned, saying
How many witness you have? One witness?
Yes, one. Only one.
What do you say?
My lord, we've been only informed of this matter 20 minutes. We have not been served mentioning.
We have served. We have
No, my
informed
lord. We've
today,
informed
but
only,
we have served.
only half an hour before, my lord, we have been informed.
We
of
have
this.
served.
Mr. Lydie, he says only half an hour prior to that he has been informed.
Served earlier. 24th
Maybe, but
December.
you have mentioned it was allowed, you have not served, notified.
Yes, my lord.
How do they know?
My lord,
Mail
Says
was
half an
there.
hour.
even in the lower court below,
Mr.
my lord.
Lydie, you have served, but you have mentioned, I have accepted on your prayer. You ought to have mentioned upon giving him a notice.
This, my lord, we
You
have
have
mailed.
only informed half an hour.
Mentioning
Because
notice.
you could have informed him yesterday.
Yes, my lord. That is an error, my lord. That I cannot, my lord.
We should have asked your advocate on record. They should have given notice before mentioning.
Takes it up tomorrow, my lord. Then. This is on 27th, my lord.
Culture, Ashun. When this matter is taken up for hearing, the learned advocate for the caveator opposition
Lordship will be taken up at 3, my lord.
That I do not know. We are given a chance. When we will again get a chance.
My lord, 27th, my
Should
lord.
have informed prior to the mentioning, even after it was upgraded. Your advocate on record ought to have notified them.
2-3 months in practice. It didn't occur to him. I also, my lord.
Yes.
If your lordship kindly keeps it at, my lord.
Yes. Next.
My lord, may I mention it tomorrow then, my lord, for taking up?
Tomorrow it will be taken up.
My lord?
Yes.
Tomorrow. Well, they may come and say that the time is not marked, so therefore they may not be able to come.
What?
Tomorrow.
Also mentioning notice then.
No, I'll serve a mentioning notice.
Tomorrow it will be taken up.
Wait for it.
Come tomorrow. Is there any caveat, Mr. Ghosh?
There is no caveat, my lord. My lord, there's a decree against me, ex parte decree, my lord. My lord, Eastern Coalfields, my lord, so suit for defamation. Decree plus.
Where is the opposite party?
My lord, opposite party, my lord, is the son of my lord, decree holder, son and daughter. Suit for
Where are
defamation.
they?
My lord, they are.
Mr. Ghosh, can you not serve them?
Only one thing I pray. My lord,
because this order was passed on December 2024.
there's a
So your bank account has been attached for that amount.
Yes, I am not on attachment. There is a Millard swift message, Millard. That's the reason I mentioned that the amount will be released. Only that part, Millard. Let Millard status quo as regards bank account today. Millard, I am ECL, Millard. What will happen, Millard? 9 lakhs, Millard. I am not running away. Millard, the suit, Millard, is a decree for defamation. Millard, there are judgments this way and that way, Millard, both ways. That after Millard, during the tenure of the Millard suit, Millard, the plaintiff dies. Millard, there is no cause of action. There is, if Millard he dies afterwards, then maybe part of the estate or Millard the execution will fail. So Millard, now Millard.
Where is that message that this amount will be swiped off?
Yes, kindly take this order in question. There's an order for release. Subsequently, I have filed. There's an order for
You
release.
have filed a subsequent revision
No.
application.
This subsequent order has come into effect after I have filed. By the 27th, the bank has been directed for compliance of this order, Millard, to release of this amount. That is, and this is the swift message, Millard, which has come to me, Millard. May I just hand up, Millard? It's from the phone of Millard, the advocate on record. Well, I'll keep the money. I'm not on the money at all. Money is already in escrow. I'm holding in the escrow. Millard, the amount, plaint, Millard, valuation is 2 lakhs.
In the civil revision application, you will praying that you will be securing this amount, so this attachment is to be lifted.
I'll secure it. And Millard, this plaint, Millard, case, Millard, is Millard 2 lakhs maximum amount. Decree for 3 lakhs. No interest, Millard, could have been paid, Millard. And then I'm willing to pay that amount. Kindly do not record that. The principal amount I've taken instruction, please pay the principal amount. Because it's law, kindly look at the prayer. I am quite surprised, Millard. Kindly have a look at the plaint, page 17.
No, that is
on merits. Kindly have a look.
On merits.
Kindly, for my satisfaction, kindly have a look, Millard. I'll secure this amount. Millard, kindly have a page 22, Millard. Millard, suit for Millard.
That is why I was asking you that if you can notify, because if you can secure, the entire order can be set aside directly. But in their absence, that cannot be done. That is the
only release. The
only
order for
difficulty.
Release is there. Kindly, Millard, stay that portion. I am securing. I am keeping the money, Millard.
Where?
That my bank account, Millard. It's ECL's bank account, Millard. Why should I go?
So you will be keeping this amount?
Yes, I'll keep
in the said account.
Already kept it. SBI already kept it, Millard. Let them not release it. This is the message I have got, Millard. Yes, sir. I'm keeping this amount. I can't, Millard.
This is the letter from the bank.
Yes, to us, to Colliery, Millard, and Millard, Mr. Partho Basu has been served, Millard. Pradipto Basu. Let them not release it. It's earmarked, kept separately. Lordship wants
sanction comply with the order means 15th of February order.
Yes. Kindly, Millard. They should not release it. I Millard mentioned. I have to keep this amount, Millard. I am without a written statement. I am suffering a decree. Only that much, Millard. And I am willing to pay the principal amount also. 318, Millard, I'll pay. Thank you. Thank you.
This order is also not under challenge. That is the difficulty.
Only that much, Millard, because it's subsequent. I did not mention, Millard, unnecessarily, Millard, before, unless this.
That is there. Mr. Ghosh, can you file a supplementary?
I'll do that, Millard. By tomorrow morning, gives me, Millard, because today is.
Mr. Ghosh, this matter was mentioned.
37.
37. None appears for the petitioner at the time of call. No accommodation has been sought for either. PO number such and such stands dismissed for default. Next.
Thirty-eight.
None appears. Dismissed for default. Next.
38 আসছে
Yes.
38
Call the next matter.
39.
লয়ার আসছে 38
None appears for the petitioner at the time of call. No accommodation has been sought for either. This application under Article 227 of the Constitution of India is at the instance of the plaintiffs praying for a direction upon the land.
The suit for ejectment, mean profits, damages. The plaintiff is the petitioner before my lord. I have come up against an order rejecting my application under Order 26, Rule 9. It has been rejected because it has been filed at
argument stage.
Yes, I tell my lord why. The suit property, it measures about 6,466 square feet. DW1 was lastly examined just a month before the arguments began, and he for the first time said that the suit property is 5,900 and odd square feet for the first time. This is nowhere to be found, and this is at a stage when the defendants have filed an application saying that we want to hand over the possession. Rather, their contention in their affidavit is that we have handed over the possession. Now, this computation of the area which they had occupied would be essential for the purpose of determination of the damages and the damages caused to the nature of the property. Kindly seize my application which is at page 89.
No, this you are inducted pursuant to some agreement.
I have inducted them pursuant to an agreement.
Yes.
My schedule of the plaint says 6466. In the written statement, they do not deny 6466. But kindly come to page 90.
90. Yes.
Kindly seize paragraph 3. Petitioner states that at the time of cross-examination to the defendant dated 1st October 24. The date is important. So and so, I have no objection regarding handover of possession, but I have objection regarding mean profit and damage. It is also surprising that at the time of cross-examination,
Mr. Chaturvedi, for mean profit, a separate proceeding will be initiated.
Yes.
So in that you can file your application.
Kindly permit me to read this, only this paragraph. Raise dispute regarding area of the suit property. He stated that the measurement of the suit property is 5922, which is not only incorrect but also arbitrary. So the actual measurement of the suit property is 6466. Now, for the purpose of what is that we are taking over the possession? Is it the same that we have handed over? No, and kindly see the schedule. I am not going beyond this. Only this much. Kindly see the schedule.
So Chaturvedi, I follow your argument, but
92
for the purpose of mean profit. So for mean profit, a separate proceeding is initiated.
But
so in that you can very well take that.
No,
that commission can be appointed to measure in that, because this mean profits will be decided in a separate proceeding.
No doubt.
Order 12
But the nature,
order 20 rule,
the damage caused to the property. Once I take over the possession, they will always say that I have caused the damage.
So don't take over possession.
No, they say that they are handing over the possession. That is their.
No. Show me your application.
Yes. The application is at page 89. And kindly see their evidence. I show it from their evidence that they want to.
Show me what are the points.
Yes.
You want to.
Kindly come to 92. To go to the locale and to take measurement of the suit property, entire go down, area so and so, to take note and ascertain the damage done to the suit property. Once I take over the possession, then it will be open to them to take the plea that they have handed over in good condition, we have caused the damage, and now we want to put it on their shoulders.
So according to them, they have handed over possession.
They are willing to hand over the possession.
They are willing to hand over possession.
Yes.
Where is that?
Yes. Kindly see is.
No, Mr. Chaturvedi.
77.
Mr. Chaturvedi, if that is so.
Yes.
So if they are willing to take to give you possession and you are willing to take back, nothing remains in the suit excepting the mean profits.
Nothing
remains in the suit excepting the mean profit. Mean profit means damages.
But the nature, kindly see this nature of the property, will have to be determined in this proceeding.
Then and there, it will be the court will record that he is handing over possession. You are taking over possession. So suit will be decreed on that date. Yes. On the basis of the admission of the parties, only a proceeding for mean profits will be there.
May I come again, Milord? Kindly see this. If I have prayed for damages and I accept the property on as is various condition, can I be tomorrow, permitted to raise the question that the property has been handed over to me in dilapidated condition? Kindly only perceive this. I am, I am, for the first time seeing a pointed 26(9) application. Kindly pointed issues have been framed. One, that for the first time, had it been there in written statement, I would have been hauled up by my lord for fishing out evidence. For the first time on 1st October 24, and the order.
I appreciate that you have explained the delay, because there is may not be any delay, because the stage when you have applied may not be delay. But
that's the ground on which it has been rejected.
Mr. Chaturvedi, the larger issue is that since now the suit was, you have filed the suit for eviction or recovery of possession in whatever.
Yes.
So now, at the present point of time, both of you have come to an agreement to that effect that he will hand over possession, he will take you.
This position is continuing since 2019. In 2019, they wanted to hand over. I am only, stuck up at a stage that I will take it only if you repair it and then hand it over to me. Not in this condition. And kindly see, the learned court in the previous order at page 101 has recorded this. Page 101. It is on their application. They wanted to deposit the earlier rents. For that, they filed an application which was.
The suit has to be stayed, Mr. Chaturvedi.
Yes. I say I am waiting since 2019. I'll wait for some more time.
Ashun, by the order impugned, the application under order 26 rule
Appealing for the petitioner in this one. Affidavit of service on the caveat. Now, my lord, plaintiff is the petitioner. My lord, in a suit for declaration that the deed of gifts executed by the predecessor in favor of the defendants, my lord, are void, my lord, illegal, ab initio, not binding. Now, my lord, on the ground of, my lord, fraud being played, my lord, or a deed of
Proviso satisfied.
Now, my lord,
Show me
yes,
the
my lord,
application
my lord, what
proviso.
happened, my lord? First, my lord, kindly takes up my plaint. First, my lord, kindly
Show me
turn.
the application for amendment,
Yes.
satisfaction of the proviso.
My lord, proviso, my lord, will come, definitely come, but, my lord, if I can show,
Come first.
my lord, if I can show that what I am trying to amend now is, my lord, already, my lord, there, my lord, the basis of my amendment is already there, and during evidence, my lord, parties have been asking questions on
Stage. What is the stage?
argument stage. Now, my lord, kindly takes up, my lord, plaint page 15, my lord, first. Then, my lord, I will take you to the nature of, my lord, amendment I see. My lord, I know, my lord, this question would come, my lord.
So
Kindly takes
satisfy
up
the
page
court
20.
on that first.
My lord, kindly page 21. Kindly comes to page 21 once.
What is the amendment which you are seeking now?
Yes. Now, my lord, during the, my lord, cross-examination of DW1, or my lord, during their examination in chief, DW1 produces, my lord, a deed of 1977 saying that the predecessor, by virtue of this deed, had become owner of the suit property. And, my lord, by virtue of this ownership, my lord, the predecessor gifted the property in favor of the defendant. Now, my lord, during this examination in chief, my lord, I became aware of the recitals in the deed. My lord, from the recitals, my lord, I find that the suit property is different, whereas
Fika property now.
no,
You are taking the plea of
I am
Fika property
taking,
also.
I am taking the plea. My lord, the property is entirely different.
Mr. Chatterjee, satisfy me on the proviso first.
My lord, I shall
not go into the merits.
My lord,
First, satisfy me
I'm
on the
not-
proviso.
My lord, first satisfaction is this recital comes in examination in chief of DW1. My lord, when DW1 was happened and when my amendment application came into, my lord, before the trial court. My lord, this DW1, my lord, takes place. File ta kothay gelo?
Mr. Chatterjee, you change another advocate, he will file another application. He will detect something more. The more you change your advocate, the more the necessity of written amendment comes.
My lord, my question is, my lord, yes, proviso attracts when? My lord, if my lord looks up to the provision, my lord, when, my lord, I being sleeping over my rights, and my lord, I have not agitated despite knowing this fact. My lord, then, my lord,
The
proviso
object
comes.
of proviso is to expedite the trial.
No, not only
Nothing more
expedite.
than that, yes.
Not only that, my lord. If in my plaint, my lord, I have taken a plea that my predecessor had no title. My lord, this plea was present. My lord, kindly appreciates this. It's not that I am changing the character of the suit by this plea. Now, my lord, if my pleadings were there, and my lord, I explain my pleadings after looking at the recital when a deed comes into a picture at the time of cross-examination. My lord, even today, if this amendment is allowed, my lord, I say, my lord, there is no requirement of further examination, cross-examination, because parties have laid their evidence onto this. My lord, questions have been put, is your predecessor and owner of the property? My lord, questions have been put whether the aunt, my lord, whose name has been found in the recital.
Then, Mr. Chatterjee,
Then, my lord, there is no difficulty in amending.
there are two things. Your amendment is based on a deed which has been marked as an exhibit. Second, you say there is no necessity to give any further evidence.
Further evidence, yes.
So what you are trying to show is to interpret the deed.
Interpret not only kindly, that's why I say
What
kindly.
comes as a result of interpretation of the deed that you wanted to incorporate by way of an amendment.
I pleaded in my original
What
claim.
necessarily follows from the deed.
But something, my lord, not pleaded. My lord, at the argument stage, it will say it is not pleaded.
Mr. Chatterjee, you need not plead the evidence. You need not plead the interpretation of the document in the pleadings. Show me that interpretation of a deed has to be pleaded. Show me.
Kindly takes up my amendment because this pleading, if it
No, I'm not looking into anything. You said deed is there. So from the deed, after going to the recitals, You came to know certain facts which you want to incorporate. Those are already there. Deed is marked as an exhibit. Make arguments before the
if
court
I
below.
just humbly just pray or submit, my lord, today, my lord, amendment which is something new is being brought in, my lord, should not be allowed. My lord, this is settled proposition of law. If parties are aware, my lord,
I follow your argument. You are trying to elaborate your case, which has its foundation in the original pleadings. I accept your submission. But this amendment is based only on the recitals of a deed. You have not stated anything, only the recitals you have stated that.
No, my lord, for my
Or
satisfaction.
you wanted to interpret something from that recitals.
Yes. Now, my lord,
That-
kindly takes up page 69 for.
That is not a ground for amendment.
Kindly takes up page 69. My
That is
amendment.
not a ground for
kindly
amendment.
takes up, my lord.
Mr. Chatterjee raised all your points in the argument. The
Well,
deeds
only
are
one-
there. There is no necessity for further evidence, as you have said.
My lord,
Will not press for any further evidence. Everything is
my
there.
lord, if this goes, my lord, what happens, my lord, tell your lordship. My lord, kindly takes up my amendment. My lord, today, both of the parties, they are brothers, sisters. Both of the
What is
parties.
the suit for?
Suit for declaration that the deed of gift, my lord, executed in favor of my brother by our predecessor, my lord, is, my lord, not binding, fraud, and obtained by coercion. My lord, undue influence. My lord, this is the basis of the deed. Now, my lord, in this basis.
So that is the only fact which you have to prove.
No, my lord, now.
That is the sole basis of your suit. That is the only fact.
No, my lord, in an amendment which was allowed.
That is only the real controversy, Mr. Chatterjee.
My lord,
This amendment.
No, my lord.
Thank you for saying that.
No, my lord, after this, my lord, we amended the plan that was allowed. My lord, in the amended plan, my lord, a paragraph was added, my lord, saying that my predecessor had no title who has gifted the property. Now, my lord, examination was thrown to me also on that count. And my lord, during his examination in chief, he
said that your predecessor did not have the title.
During my cross-examination, he put that question to me. That your predecessor, our predecessor had a title. Now, my lord, when his examination came in, my lord, in chief, he relies upon the deed of 1977. Now, my lord, when I looked into it, after it was surfaced before the court by Exhibit 1, now, my lord, when I looked it, I found from the recital that the suit property is entirely different, my lord, by virtue of which, my lord, our predecessor, he says, became owner of the property which was gifted to him. So, my lord, now, my lord, I want to incorporate by way of this pleading that of the deed, the suit property is different. That is the sole.
Need not have to incorporate that. The deed is on record. The suit property plaint is on record. You have to show that this is the deed, this property, this is totally different.
Well, only then clarifies this position, I will be entitled to raise my argument on the basis of the recital of the deed. Otherwise, tomorrow, if it is said that it is not pleaded, but I should not be thrown out because of non-pleading. Because parties are aware of the issue, they have led their cross-examination on that issue. So, therefore, clarifies this and do not require Muller amendment.
Kindly have a look at the plain case.
Use the microphone.
Kindly have a look at the plain case, page 16.
16, yes.
It's a categorical admission that the father was the exclusive owner of the property in question. Page 16.
That's why I wanted to show page 21. I know Mr. Haldar would show that.
One Gopal Chandra Rai was the exclusive owner of the property containing an area of 3 katas, 8 sheet acres of homestead land, together with big built asbestos structure existed thereon and lying and situated at premises number 25/8A. That is their statement. 25/8A, Kakurgachi Road, at present known as 25/8A, Upendra Chandra Banerjee Road. Their contention in the deed, it was written as Kakurgachi Road. Now they are saying, it is Upendra Chandra Banerjee Road. It has been renumbered, and it is also the case of the plaintiff also. And the above named sole owner during her possession and enjoyment of the suit property with his wife, the pro forma dependent herein, and 3 sons, plaintiff and the dependent herein, passed away without making any arrangement and without ratification of any will in respect of the said property in any manner. Then, my lord, kindly straightway come to the, my lord, the prayer portion of the plaint. Page, my lord, 25. For a decree of declaration declaring that the deed of gift registered at the office of the DSR 3 Alipur, South 24 Parganas, recorded in book number 1, CD volume number 19, page number 86 to 108, being number 059334, for for the year 2007 and book number 1, volume number such and such, my lord, for the year 2007, registered in the office of DSR 3, Alipur are void and void ab initio and is not binding upon the plaintiff. For a decree of further declaration that the said to registered deed of gift, those have been prepared under coercion and fraud, are neither valid nor enforceable in law and is also not binding upon the plaintiff. And my lord, the prayer D, for a decree of declaration that the existence of said two deeds of gift have been extinguished forever on account of ratification and registration of the same under coercion and fraud. So, my lord, his specific cases of the plaintiff is that
Mr. Chatterjee, if you succeed in the suit, then you will be a co-sharer in the property. So you do not want further relief in the suit.
My lord, if I succeed in showing, my lord, the property which they are having, my lord,
You have not prayed that for declaration of your share. You cannot be the
Lord.
exclusive owner. So your plaint case is that you are the joint owner.
my lord, my plaint case, my lord, is, my lord, to
Paragraph 2.
yes.
Plaintiff and the defendant pro forma have inherited the property
Yes, yes,
left
that's
by
why I
the.
said, that's why I
But
said, my lord,
kindly come to your prayers in the plaint
Yes.
for declaration of your right. You have not specified your right. You have not said that you are a co-sharer declaring your share in the property.
And
further reliefs you have not prayed for, Mr. Chatterjee.
And by virtue of proposed amendment, my lord,
prayer C.
Yes.
Prayer C of the plaint.
Yes.
For a declaration, the plaintiff reserves
Reserves his right. You have not prayed for your
Lord, language is not that clear, but reserves, my lord, is
declaration
having-
of share also you have not said.
declaring that the plaintiff reserves his right.
His right.
Title and interest, both.
Yes.
All three.
What is his share? You are not
Because
the
this is not a
absolute
suit for
owner.
Partition. My lord, definitely, if I succeed in this, I will be
Why?
1/3.
Why? Why in the future suit?
My lord, today,
Why not
unless
in this?
deed goes,
Here, Mr. Chatterjee, your possession, right to enjoy is at stake.
my lord, kindly recalls the Akamba's judgment of 2021. It says, my lord, section 34, even if, my lord, I miss out a relief, my lord, for not missing of a subsequent relief, my lord, the main relief cannot be, I cannot be disallowed the main relief. That's the recent decision of Akamba in 2021. Now, if that be the position, my lord, today it cannot be said
So
that
this
for
is,
not
this
praying
according to
partition,
you is the consequential relief.
my lord, this
Your
according
declaration
to,
of your title.
my lord, my primary relief is setting aside of deed of declaration.
And this will be your
My lord, this
secondary
will
relief.
follow this, my lord, upon declaration, my lord, that would follow. My lord, if I do not succeed, my lord, then, my lord,
All right, let us not go that far.
yes.
I've seen your plaint.
Now, my lord,
So,
kindly takes up paragraph, page 21, paragraph 12.
yes, what is page 21, paragraph 12?
My lord, we said, indeed, the father of the parties to the suit
This is what?
This is the paragraph of the plaint. My lord, he relies on paragraph 1 of the plaint. My
Yes.
lord, I rely upon paragraph 12.
So it was amended earlier.
Amended, yes. That was allowed. So, my lord, I said.
So this is the second amendment or the third amendment?
This is the second amendment.
Page 21.
Page 21 is the first amendment.
Yes.
That was allowed.
Paragraph, which paragraph?
Paragraph 12A, my lord.
12A, yes.
Indeed, the father of the parties to the suit had no capacity either to ratify an instrument or to register the same or transfer the same to transfer the property in dispute or to its part thereof in favor of the defendant or any other person. It is indispensable to emphasize on the point that the father of the parties to the suit was never acquired ownership of the property which is sub judice before the learned court, and thus the aforesaid stated two deeds of gifts, those were procured by the defendant under coercion, fraud, and brought into existence for the illegal gain, are neither enforceable nor reserve any value to effectuate the contents of the said so-called instrument brought into existence in a crooked way. So, my lord, it's an inconsistent pleading, maybe, but this is permissible in law. So, my lord, if this is permissible, my lord, now from the recital it is found, the premises numbers are being different, the lanes are being different. Lord, therefore, my lord, I
raise all those issues.
That clarifies this. Lord, I only clarifies this, I did not bring into amendment. This pleading, because of non-pleading, I should not be thrown out.
This application under Article 227
Item number 37 and 38, I am waiting for.
37, 38.
Milord, I went to the washroom, Milord.
What has been done?
It was dismissed.
Expeditious hearing
Yes, Milord.
of a proceeding pending before the Land Reforms and Tenancy Tribunal, whether the single bench can entertain such an application in view of the specific bar laid down in the West Bengal Land Reforms and Tenancy Tribunal Act, which says an application under Article 226 and 227 can be entertained only by the division bench of the High Court.
Milord, it is just expeditious hearing.
I can take that, pass this order on merit.
Milord, it is, kindly get it on.
Single bench cannot take up.
Milord, expeditious can be allowed.
Maybe express bar in the West Bengal Land Reforms and Tenancy Tribunal Act 227, 226 can be entertained only by the division bench. So this forum.
Only the expeditious after.
Sir, if the court cannot entertain an application in view of a specific bar, can any order be passed? That will be without jurisdiction.
There is several order, Milord. I will satisfy tomorrow, Milord.
What?
About the
what several orders?
Milord, about the expeditious hearing of the LFTT matter. I got the judgment. Milord.
Maybe you have got the judgment. Bring El Chandra Kumar's case, whether this was considered and the provisions of the West Bengal Land Reforms and Tenancy Tribunal Act.
Obviously, the time giving after.
I have delivered a judgment. Bring also that.
Milord, to tomorrow, Milord.
Bring also that. And whether the other judgments considered that, that is also to be taken into consideration. Whether these provisions of the West Bengal Land Reforms and Tenancy Tribunal Act was considered, L. Chandra Kumar considered, Constitution being judgment. I am bound by that.
Milord, tomorrow, Milord.
You are inviting an order on that issue.
Milord,
think about this matter.
Yes, Milord.
You are inviting an order on that. All right. 37, 38 যেটা dismiss for default হয়েছে ওইটা recall করে দিয়ে লিখুন the learned advocate appearing for the petitioner prays for an accommodation